A warm welcome to distinguished guests, moderators, panelists, and all attendees attending in person here at the AIAC Auditorium and virtually on Zoom. My name is Jensen.
My name is Vicky. We are the MC for the HHQ and HLP Inaugural Joint Conference 2022, jointly organized by Mrs. Halim Hong and Craig and Mrs. Harold Lam Partnership. This is a hybrid conference. We have participants joining us both physically in the auditorium hall of AIAC and virtually via Zoom.
On behalf of the organizers, it is my great pleasure and honor to welcome Dato' Ho Hon Sang, the Deputy President of RADA Malaysia. Thank you, Dato', for being with us today.
Ladies and gentlemen, without further ado, we would like to invite Dato' Kwek Ee Ming, the Managing Partner of HHQ, to deliver the opening remarks.
Thank you, MC. Good afternoon to Dato' Ho Hon Sang, Deputy President of RADA Malaysia, to the distinguished speakers, and also the clients of HHQ and HLP. Thank you so much for attending this inaugural conference organized by Harold Lam Partnership and also Halim Hong and Quack. The last time that where we have the physical conference is about 2019, 3 years ago, before the pandemic, we organized here. And it's good to see some of you back here. Thanks. You want to clap? Please clap. Thanks. Yep. Since the implementation of this lockdown under the MCO 2.5 years ago, definitely we can't have many, or we just could not have any physical gathering or meet-up or briefing on the update on the law. However, as a firm that guided by the mission to empower everybody with law, we didn't stop to share all the case and legal update with our clients. We did that for the past 2.5 years. We keep our clients, the public, informed what's the latest in the law. We also work closely with RADA Malaysia for the past 3 years on a pro bono basis, because we are being positioned as a full service firms with real estate specialists. This is what HHQ is. And of course, today we have HLP, a construction specialist. And both join together to provide a full service from A to Z under this real estate and construction. From the moment that any contractor or any developer would like to engage in this industry until they would like to list their company, we can provide services from A to Z. But I will come back to that, the commercial section in a minute. But first, I must thank all of you, particularly the Deputy President, Dato' Ho, for gracefully agreed to come here. Your time schedule is very tight. You are working. You contribute a lot for the real estate industries. You are working under this very high demanding, high intensive firm that all of us know about that. And yet you can squeeze time to participate in RADA activity for the well-being of the entire housing developer industries. And at the same time, I know that this morning you managed to produce good lawyer. Dato' Ho's daughter actually worked in Allen and Overy. And yeah, much to learn from you. Thanks for coming. And Dato' Ho has a function afterward. Immediately after his speech, he got to excuse. Yep, we definitely thank him for coming. And all the panelist speakers, all the speakers agreed to step up and share knowledge. And also the organizing committee. Thank you so much, Leon, Yan Yi, Jet Lai, and your teams for putting this event successfully. Thank you. For the immediate the following 3 hours, we'll be sharing 3 sessions of the legal topics. And the lawyer that we invited are from HHQ and HLP, and they specialize in both real estate and construction area. With their diverse, with their insight for the past few years, they are able to share with you their insight and also offer practical solution on gray area. And I hope that you find this conference fruitful. And coming back to this HHQ and HLP, we established our alliance about 2 years ago. It's so easy for us to join force together because we have been working on many pro bono, many voluntary works. I myself, I knew Wai Long, I knew Herok, and it's good to find someone that the value are shared and the interest can be aligned. And hence, when we collaborate, we are happily doing all this joint recruitment, business development, training together for the good of both our lawyers and for the good of our clients. Through this alliance, that from real estate and construction, we are able to provide high quality and also cost-effective legal services. And now, any client want to come to us, asking us any questions on real estate or construction, we can offer one-stop shopping for you. And together, our workforce is 140 with more than 60 lawyers, and it's still growing the number. Today is the first time that we join forces to organize a physical and hybrid seminar. And let's keep the ball rolling. I hope that you'll be leaving this room being empowered with the topic presented afterward. Thank you so much.
Thank you, Dr. Craig.
Ladies and gentlemen, I'm pleased to invite Dato' Ho Hon Sang, the Deputy President of the Real Estate and Housing Development Association Malaysia, to deliver an opening speech. Dato' Ho needs no introduction, but please allow me to share a short one. Dato' Ho is the Group CEO of the Masing Group Berhad. He is also the Deputy President of REDA Malaysia, 2022 to 2024, and the immediate past Chairman of REDA Selangor, 2022 to 2024. Let us give a big round of applause to welcome Dato' Ho Hon Sang.
Thank you very much. First of all, on behalf of REDA, I have to extend my greatest appreciation to Dato' Quek, Tin Chong, Wai Lun, and Harold for working very closely with REDA over the past 2 to 3 years, especially on many legal issues, and also the amendment to the Act 118. I call this the pillar act of the real estate industry in Malaysia. And we have been enjoying very good working relationship. Anyway, thank you very much. So ladies and gentlemen, a very good afternoon, and thank you for being with us here today. It is a pleasure for me to welcome you to the inaugural joint conference by Halim Hong and Quek and Harold Lam partnership today. I'm honored to be here and would like to thank both HHQ and HLP for inviting me to say a few words this afternoon. On behalf of REDA Malaysia, we are pleased to join the session today, as I believe that this conference is a good platform to exchange the best practices with other industry players pertaining to the newly implemented law, i.e. the real estate industries and the recent amendments to the Employment Act, and how it will affect the property and construction industries. It will empower attendees with the necessary information to move forward to serve the industry better, the nation, and ultimately the rakyat. I'm sure this timely event will benefit all property players and stakeholders in many capacities. Ladies and gentlemen, RADA, being the developers' voices of the nation, commends the effort by Halim Hong and Quek and Harolam Partnership in organizing this conference, which I'm sure will be able to address the many pressing issues facing the industries, especially in the recent years. The conference today will feature 2 presentation sessions on tax issues in the real estate and construction, and an in-depth look into the new amendments of the Employment Act 2022, which was recently gazetted. We will also have a panel discussion on the issues faced by industry stakeholders in regards to getting projects ready for delivery of vacant possession, especially residential developments. I hope all attendees will be able to gain invaluable knowledge and information throughout the sessions, and thereafter apply the knowledge to practice towards the betterment of the industry. On that note, I would like to once again thank Halim Hong and Quek and Messrs. Harolam Partnership for inviting RADA to be part of this event. My congrats to the organizers for holding this inaugural joint conference, which we hope will be the first of many. Thank you, and have a fruitful session and evening.
Thank you, Dr. Ho. Please step down to the front of the stage. We would like to invite Dr. Quek, accompanied by Mr. Lam Wai Lun, the co-founder and partner of HLP, Mr. Leon Gan, the partner of HHQ, who is also the chairman of the organizing committee for this conference, and Ms. Felicia Lai Wai Kim, the associate of HLP, who is also a member of the organizing committee for this conference, to deliver a token of appreciation to Dr. Ho. Thank you, Dr. Ho, Dr. Quek, Mr. Leon, and Ms. Felicia.
We will begin our conference today with our first session, where the panelists will be discussing the tax issues in real estate and construction. We would like to invite the moderator for session 1, Ms. Noelle Law Pui Vun, and panelists, Mr. Harold Tan Kok Leng and Mr. Desmond Liew Tzu Hong, to come to the stage. Ms. Noelle Law, the moderator for session 1, is the Senior Associate of HHQ. Her practice areas are focusing at banking and finance, corporate and commercial, and real estate and project development.
Before I pass the floor to our Section 1 moderator and panelists, this is a gentle reminder that we have 40 minutes for this panel discussion. When the session has another 5 minutes left, our production team will give you a friendly reminder or notification. If you hear the second friendly reminder or notification like this, we would be grateful if you could kindly wrap up the section. Without further ado, Ms. Noelle, the floor is yours.
Thank you so much. Hi, ladies and gentlemen. A very good afternoon. I'm Noelle, and as introduced, I'm a senior associate at Halim Hong and Quek. And with me today, we have Mr. Harold Tan Kok Leng at the middle here, and Mr. Desmond Liew Hong with us. And they will be speaking on the tax issues in real estate and construction in this first session. And then please allow me to take a couple of minutes of your time. I would like to introduce our speakers. So Mr. Harold is actually one of the founding partners of Harold and Lam Partnership, and he's a member of the Law Society of the New South Wales, Australia. He is also a fellow of the Chartered Institute of Arbitrators and is a panel arbitrator of the Asian International Arbitration Center. Harold's main areas of practice are commercial and tax dispute resolution. And having been in legal practice for more than 20 years, Harold had advised and represented many clients in their tax disputes and with the tax authorities, both in court and settlement negotiations. And Desmond is a tax partner in HHQ. He has more than 8 years of Malaysian taxation experience, including 4 years as a tax consultant and one of the big 4 audit firms. He works on all aspects of tax and revenue law. In particular, regularly, he represents taxpayers in tax disputes, handling tax audits and investigations. He also regularly advises on tax issues arising from corporate transactions, which include mergers and acquisitions, corporate restructurings, cross-border transactions, regulatory compliance, employment, TMT, IP, real estate, as well as land matters. He has been recognized as one of the key tax lawyers in Malaysia by Legal 500 Asia Pacific 2022. Okay, move along. Let's welcome Harold and Desmond to start off the first topic. Both our speakers will be addressing 3 main topics of these tax issues today. So let's go on to bad and doubtful debts as the first session, as the first topic that Desmond would like to share with us. Desmond, would you be able to maybe illustrate what are recoverable debts and the reversible debts that we would like to share?
Thanks, Noelle. Hi, everyone. Good afternoon. I hope the lunch doesn't kick in the food coma. Okay, there's a lot of tax issues that we would like to share, and the selected 3 is bad and doubtful debt, RPGT versus income tax, and as well as director liabilities under Section 75A. So for bad and doubtful debts, it's not not often that I came across this issue that went up to the court, but I regularly being engaged when a taxpayer was caught by this issue during tax audit. So why taxpayers always get caught by writing off bad debts and doubtful debts during tax audit? The main reason is due to the vast difference between the taxpayer own method and policy in handling bad and doubtful debts as opposed to the tax treatment in relation to bad and doubtful debts. So now, let me give you some example. Taxpayer often than not, their method and policy in managing their bad and doubtful debts are driven by accounting policy or accounting standard or even commercial decisions. For example, some taxpayers that I came across, they will write off the bad debts because for them, the amount is too negligible. Or some even just write off the bad debts because of some accounting policy for over a period of time. Say, if the amount of if the bad debt remain not collected for, let's say, for a period of, say, 9 months and above. Some, the more prudent one, they will park this bad and doubtful debt and into a provision account and monitor from there on. And sometimes when they monitor from there on, they forgot to monitor properly as well. So these are the usual method. What you can see here is that they don't usually consider the tax treatment when they are adopting their own method and policy in handling the bad and doubtful debts, right? So whether the question is always, when the client came to me, I will say, whether you have evaluated each and every of your debts specifically, knowing exactly what reason this debt is being outstanding and why it's not recoverable. And secondly, what are the reasonable steps that ought to be taken and have taken, and whether it has been documented. So what are the reasonable steps that ought to be taken or have taken is reminder emails after you have sent your invoice, after the credit terms have lapsed, following whether you have sent sufficient reminders, letter of demands, and if the amount is commercial viable to take a legal action, whether legal action has been taken. These are all the questions that the revenue will look at and tackle and challenge you all when we come to bad and doubtful debts. So perhaps I can invite Harold to share on the case study on this.
Thank you, Desmond. Perhaps let me share with you a real-life example of a tax case that I handled before that deals with this particular issue of bad debts writing off. I acted for a main contractor who was engaged in the work in respect of a project called the district cooling. Right? The work had been completed, and the final claim was issued to the employer for payment. Unfortunately, dispute arose between the parties that led to the main contractor initiating arbitration against the employer. The employer, on the other hand, counterclaim against the main contractor, alleging issues such as defects and delays. All right. At the very initial stage of the arbitration, the parties managed to reach a settlement whereby the employer was willing to pay about 1/3 of the amount claimed by the main contractor. All right. This was accepted by the main con. And for tax purposes, the main contractor declared the 2/3 balance amounting to about 2.25 million as a bad debt, and sought to claim it as a bad debt deduction for income tax purposes. So that is how the transaction happened. Some years later, there was a tax audit, and the tax authority basically challenged the main contractor's entitlement to claim a bad debt. All right? So the matter was actually litigated in court. And to cut the matter short, the court ultimately found in favor of the main contractor. All right? It held that the main contractor had actually satisfied the requirement of taking all reasonable steps, all right, to try to recover the debts that ultimately could not be recovered due to the settlement. Okay, what are the takeaways that we can gather from this particular case study? Okay, firstly, the first point that I want to highlight to you guys is this. The contractor, the taxpayer, is only required to prove they have taken all reasonable steps to try to recover the bad debts. All right? If after all reasonable steps have been taken and the debt still could not be recovered, then it could be a case of irrecoverability, entitling the taxpayer to a tax deduction. For example, in this case, it is not expected or required of the main contractor to pursue the arbitration to its conclusion. All right? In this case, the High Court accepted our argument that the decision by the main con to accept the settlement is a reasonable one, based on valid commercial consideration. So that is the first point. The second point I want to make is this. It illustrates the importance of record keeping. So in this case, the main contractor had actually had good record keeping, whereby the decision, the reason of its decision in accepting a 1/3 settlement was properly documented in contemporaneously email as well as internal memos of the main contractor. Well, this came in very handy in the argument and to prove that the decision to accept the settlement is a sound one based on sound commercial consideration. All right? So those are the two main takeaways that I can think of with regards to this case study on this topic.
Thank you, Harold. And perhaps Desmond, would you like to elaborate more on the self-evaluation to the audience?
Yeah, thanks. Thanks, Harold and Noelle. So I think we can't put more emphasis on having sufficient record keeping, because most often than not, when I was engaged, I was starting to ask for A to Z, all these documents, and my client will always tell me that they only have two things. This don't have, then that don't have. So I was like, ayo, then how am I going to, even defend you guys, right? And for bad debt, another example I can think of is that when we ask for follow-up emails and stuff before you actually instruct your solicitor to issue a letter of demands, the client will always say, oh, I think we have, but we can't locate the email. Then the executive come to me and say, Desmond, call other lah, call, boleh? Then I was like, oh. Then I asked her back, do you want to stand in the witness dock to testify that you have actually made this call and stuff? So hence the importance of record keeping, sufficient record keeping for tax audit purposes. And you can see the number one item here. I think this is very important that I realize a lot of clients don't have is, do we have a credit control mechanism? In other words, do we have a policy to manage your bad debt? If yes, then maybe you want to check against whether there is in compliance with tax treatment as well. Okay, back to you, Noelle.
Thank you, Desmond. Okay, both Desmond and Harold has actually covered the first topic of the session, and now we're coming to the very popular topic, one of topics, which is RBGT, the real property gain tax versus income tax. Desmond, would you like to start off with the differences?
Yeah, thanks, Noelle. Okay, RBG versus income tax. Every year, without fail, I will get at least one or two clients that came to me and say that, Desmond, I got this IRB issue me an assessment for my disposal 5-10 years ago, this particular real properties, and now they say that it's not supposed to subject to RBGT but income tax. Then it's back the question why, right? It's actually really no-brainer because IRB always do this due to the vast difference in rates. RBGT, as all we know, individual 5, 3, or 0, depending on which year, and to the amendment of the Schedule 5. Corporate 5 or 10, right? If let's say in the 5th year or 6 years. So the difference, corporate income tax, let's just take corporate income tax for example. Corporate income tax, 24%. So the difference is at least 14%. And that 14% coupled with penalty rate, and more often than not, they will impose a rate at 45%. That's like their lucky number. You actually see 45% there. And so this is one of the reasons why IRB love to audit and pick, I will say, subsidiaries of property developers or even property developers themselves when they disposing some lands for development purposes. So let me give you a recent case that I have done. My client is a plantation company, right? So they bought a huge piece of land right smack in the middle of a forest. It's actually located in the middle of the Hiew in Pahang. So in result which, right, the plantation land is unduly terrain, cascading, and 500 meters above sea levels. So in subsequently 6 years down the roads, my client have got a very, very, very good and irresistible offer due to Musang King bloom, where people actually exporting frozen durian to China. So the durian lands got appreciated like crazy. So he got a really good offer. He sold off the land. Immediately, 2 years after he sold off the land, IRB came and audit, and subsequently, in this particular case, within 2 months, the assessment was issued. So the IRB, when they do a tax audit, they already have their mind fixed. They're going to issue a tax audit. And they gave us a lot of bizarre reasons. One of the reasons is, among others, I would say that is they allege my client wanted to develop the land. So I tried to reason with them. Look, my client even sent a drone to take a picture of the land. It's right smack in the middle, in Pahang. It's in the mountain, and the nearest village, it's not even town. Nearest village is 15 km away. So IRB say no. They give me another bizarre reasons that I quite worry, which is they say, oh, because one of the shareholders and also directors has knowledge and skill in property development. Then I was like, how is that so? So I asked him to kindly enlighten me in this regards. And he said, you see, based on our SSM search and our own intelligence search, he is actually sitting as a director in a property development company. And henceforth, he has inferred the knowledge and skill into this plantation company. So totally disregard the separate legal personality doctrine. Solomon and Solomon, they don't even know, I think. So this is, and eventually we fought the case. We filed a judicial review. We stayed the assessment. We got a stay order, and we fought all the way to Court of Appeal. And simultaneously, I maintained communication with the IRB CEO office and also the Jabatan Undang-Undang, which is the Remuneration Council. And ultimately, the matter was settled for a settlement sum of just only 10% of this assessment amount. The assessment, I would term, is a mega amount. So this actually show how unreasonable IRB could be in order to meet their collection targets, and how vulnerable taxpayer in such matter. All they need to do is to make some baseless allegations, issue an assessment, and unfortunately, because our tax regime is pay first, talk later, unless you get a stay order and stay, otherwise pay first, talk later. And whether or not judicial review is the default route for us to appeal, I mean, I would love to discuss more in depth in this, but I will take this separately, you know, in other seminar or conference with you all, and due to time constraint. And now I will invite Harold to share his case on this.
Well, I have a slightly different experience from Desmond's, and I will share this. I represented and advised two husband and wife retirees who, through their sheer hard work, managed to accumulate a basket, a portfolio consisting of about 14 shop offices for investment purposes. So these properties were purchased by them from 2005 to about 2010. They were parked under an investment holding company of theirs. So all the properties were located in the vicinity of Puchong where they lived. So the intention had always been to have this portfolio of properties for rental purposes. So throughout the years, the rental that they have collected, they have actually declared and paid income tax on those rental proceeds. Unfortunately, due to the economic downturn, 8 out of 14 of these properties could not be rented out. So to ease their financial burden, they have decided that they have to offload some of these properties, which they did, 6 in 2012 and another 3 in 2017. 9 properties were sold, and for all these 9 properties, they had paid RPGT. All right? So fast forward to 2021. Again, it all happens because of a tax audit. So the tax authority took a position that says that the disposal of these 9 properties by them amounted to trading, which is subjected to income tax. Right? They were slapped with an assessment of 1.8 million on these 2 retirees. So they came to us and an appeal was immediately filed. So in this experience of mine, the case was finally actually settled with the IRB offering to reduce the 1.8 million tax assessment to 600,000. All right, this was accepted by the taxpayers. All right, so again, what can we learn from this case study? Again, firstly, I would say that in order to determine if the taxpayer is holding the properties as investment where RPGT is payable, or they are actually to be taken as carrying on trading business of buying and selling properties in which income tax will be payable, then we have to tackle that issue from the perspective of what we call badges of trade. Badges of trade is basically a basket of considerations that the courts had actually taken into consideration and debated for throughout to be relevant to decide what is the predominant purpose of the purchaser when acquiring a particular piece of property, whether it's to be held as investment or whether it's to be held for trading. All right? So that is how this issue is being looked at. So in this particular case, all right, what the dominant purpose of these two retirees, which is to have the properties rented out to generate rental income, right, is supported by the fact that they had never advertised the properties for sale. And they had only through their properties agent advertised the properties for rental. All right? Of course, the location, the locality of the properties is also relevant. They stay in Puchong. All these properties that they purchased were in Puchong. And why is that so? It's because to ease them managing these properties. So there are many other considerations too, which is categorized and described as badges of trade. So that's number one. Number two, from this example, we can also see that not all cases at the end of the day needs to be litigated, right? In this particular case, the case was amicably settled, although they still have to pay 600,000. The IRB was still willing to refund them the 1.2, right? And this can be done by way of persuasive, carefully prepared representation to the IRB, which is how we managed to get this resolved to the satisfaction of the two retirees. Okay, so that is what I want to share with regards to this topic.
Thank you, Harold. Desmond, would you like to share further about badges of trade and how is it relate to the self-evaluation questions?
Yeah, can. Thanks, Noelle. So, badge of trades, you know, I will give 3 examples that may be closer to us. First is frequency of transactions. That some of you or your company, if frequently dealt with buying and selling of properties, then I will say that you are definitely under IRB radar. And secondly is the tenure of ownership. If you hold the property for the shorter you hold, there's indication that you are actually flipping it and you are not actually holding for investment purposes. And third will be the method of financing. If you're taking a short-term loans, then it's reflective and indicative of you wanting to flip it and hence for its revenue in nature and not capital and investment in nature. So all these, all in all, when we discuss about this page of trade, I mean, based on my own monitor, they are actually, the courts have developed up to 16 pages now, but I don't intend to share with you all 16 now today. But the key takeaway here is that all these 16 pages, or the prominent 9, they ultimately go back to one thing, which Harold said just now, is the intention. So how you then crystallize your intention to say that, you know, this particular transaction is capital in nature and not revenue in nature. So we have 3 self-evaluation questions here. If you have any high-value real property transactions, you might want to revisit it again and see whether it's being done properly and whether there's sufficient record keeping that have documented the intention during purchase and disposing the particular real properties. And do you have any transaction that during RPGT exemption period, although the RPGT exemption period is 1999 and also 2000, early 2000, but you might want to revisit all this. And lastly, are you a developers with RPG returns? Because developers should be filing income tax for disposing the real properties because these are the inventories. So if you have any, do the self-evaluation and see whether you're under the radar. Back to you, Noelle.
Thank you, Desmond.
I just want to add one important point is that the time in which the law determines intention is actually at the time that the property was acquired. What was the then predominant purpose of the acquisition at the time of purchase? So at the time of purchase, if we can prove that the intention was for investment, but subsequent, because of market condition, you have no choice but to sell, it will still be considered as an investment. All right?
Harold just reminded me that I need to, another indicator of the risk or the minute that you guys may step on is that, because a lot of developers here today, before your media, PR, or investor relations going to publish anything about maybe your biography of your founders or how this particular icon project is being found, before all these statements is being published, right? I kid you not that one of the really major developers being caught because of the founder media statement of how he founded this particular project. And IRB actually investigated him because of this particular media statement and biography, that how this project came about, which bring to what Harold says just now, your intention when you purchase this land, and therefore it's not for investment purposes, but to develop a mega project. So I would say a big highlight to you all here today, especially the developers. Yeah, back to you, Noelle.
Okay, thanks, Harold. You have anything to add for this topic? No? So now I think we go to the next topic, which is also the last topic of this session. This is also an interesting topic to share about. It's about the director's liability under the Income Tax Act, 1967. Perhaps we get Desmond to start off to share his experience in this.
Okay, thanks, Noelle. So, director liabilities is really, really straightforward. Being a director, of course, naturally a lot of exposed to a lot of risks and liability. And in particular, in the context of income tax, director definitions is if you're a director under Section 75, means that you are a director, and also at the same time you are the shareholders that holding not less than 20%. And this 20% shareholding, you can see in the slide here, is 20% or more, including indirect shareholdings and shares owned by associates. Harold will share more later on these associate parts. And I just want to share what on this Section 75A director liabilities is really quite straightforward, 20%, and then you will be joint, and also a shareholder and directors, then you'll be jointly and severally liable for any tax liability of the company. And the tax liability, more often than not, my client will tell me that no, paying the amount is not an issue. What really became an issue is when all these directors, maybe yourself sitting here, or your founders, or the key management personnel, enforcement legal action was taken by IRB. All of you all will be then named as the defendants, and subsequently answer to the claim. And that is actually not the biggest headache. The biggest headache that I often got from my client is that when they are actually at the departure gate, they say, Desmond, I actually blacklisted. Travel restriction is being imposed on me. So that is actually, I would say, the real problem that disturbed my client when enforcement action was being taken, when they are blacklisted, they cannot travel. It's really handicapped and also paralyzed and disturb the business operations. Yeah, plus I will get Harold to share more on this case study on director liabilities.
Yeah, before I share with you my experience on the case that deals with this, I think I'd like to explain a bit more on the indirect shareholding and also shares owned by associates that can be deemed to be shares of the director. Right? Associates is actually defined very, very widely in the Income Tax Act to include husband and wife, even parents, even brothers and sisters, and even children. So, for example, if you are a shareholder of, you own 10% and your wife owns 10%, Individually, you would not cross the 20% threshold. But because it's owned by your associates, so both of you and your wives actually had met that threshold. And if either one of you is actually a director of a company, you call it a Section 75A director, is personally liable for tax obligations of your company. So that's how dire and important this particular aspect of tax law is. All right. Okay, now just to share my experience in having dealt with one of these cases. It should be explained that, prior to 24th of January 2014, the threshold requirement is actually 50% or more. But this had been then reduced in January 2014 to only 20%. All right. In 2015, I represented a director of a company who was sued for a Section 75A scenario for 15 million ringgit debt of the company. It's a company's debt. But this director was sued personally for the 50 million. The assessment was raised in 2015, namely after the amendment. But it's in relation to years of assessment prior to the amendment in 2010. So the matter was litigated. The court was with us and struck out the IRB's claim. For a simple reason that at the material time, this particular lady was did not meet the 50% threshold. So again, what can we learn from this example? Of course, firstly is that, you can see that IRB basically is capable of taking even the most seemingly untenable positions in order to reach their collection target. And secondly, more importantly, you can see from here that the IRB actually have a way of tracking Section 75A directors. All right, so we have to be very careful so as to not unwittingly become such a director and be personally liable for a debt of that company. All right. So I think we can go on to the next slide on self-evaluation. Maybe I'll just, question one is, are you a Section 75A director? Okay. There are many times where we may become one even without us knowing it, which is why I think that it's very important for all of us to actually sit down and reconsider our company structure. Okay, so for example, I have a company that I co-own with a business partner of mine, not my family members. I'm a minority shareholder in my own company. Let's say I'm only a 40% shareholder, right? The company of mine owns a particular piece of land which I want to develop. I enter into JV with a property developer. So SPV was formed 50-50 between my company and the property developer. I appointed myself to sit on the board of the SPV. Question, am I a Section 75A director? The answer is yes, I am. Why is that so? It's because of my indirect shareholding in the SPV via my 40% ownership in my own company. So 40% on that 50% is 20%. And I'm a director of the SPV. So I am caught. Second scenario, I don't appoint myself as a director, I appoint my wife as a director. Surely my wife has owned no shares in my company. My wife is also not a shareholder of the SPV. Surely she cannot be a Section 75 director. Unfortunately, she is a Section 75 director. And why? It's because of her association with me as a husband. So being a Section 75 director in that scenario, my wife would be unwittingly taking on the liability to pay for any outstanding income tax debt of the SPV. Is that fair? Certainly not. But is that the law? That is the law. All right?
Yeah, so adding on to what Harold says, hence the importance of your reviewing your shareholding and directorships of your companies and your group of companies. So why we emphasize this is a lot of my cases, I mean, extended from the RBGT versus income tax, I will always found that those subsidiaries that was formed to help Lend then was still in existence, and more often than not, the shareholder and director of this land, maybe because the value of the land is very high, it's more often than not, I was to my surprise, is the founders or their next of kin. So they were unnecessarily implicated, you know, after the transactions, for the reason they are still a Section 25A directors in that company, and also the company is still in existence, the subsidiary is still in existence, even though JV was formed, construction was done and dusted for a good 10, 20 years. So it's really alarm to you all that to review your group structure, and to you all that who is the director sitting here today, to check whether you are Section 75A director. Yes. Yeah, and adding on to the great difficulties, inconveniency that I emphasized just now will be the travel restrictions. And so some tips from Desmond today is that if you will get travel restrictions, how to get about it is not only call Desmond. Before calling Desmond, before you fly, you can actually go to this website, immigration website, and put in your IC number and see whether you are blacklisted for whatsoever reasons, because you might have 75 ringgit that long and due payable with the IRB that you don't know. And that's why I always joke myself that although I'm not a criminal lawyer, but I will still keep my phone on at the midnight, because sometimes my client will call me and tell me that, hey, what should I do? I can't fly. I will say, what can you do? Go home and sleep, because there's really nothing for you to do. If you call me in the morning because your flight is in the morning and you are fortunate enough it's a flexi ticket, then I will tell you, go to the nearest IRB office from KLA, which is Cyberjaya. I will meet you there, and we will negotiate with the officer and pay a minimum sum, because you have no risk of absconding. Then you still can go and enjoy your flight. But if really in the middle of the night, I will really don't get angry with me. I will just ask you go home and sleep. Okay? Back to you, Noelle.
Thank you, Desmond. Interesting facts. Humorous facts as well, but it happens. Okay, I think we are about time to take on questions from the floor. Any questions?
Hi, James Tan from a developer. I have a question for Harold. That aircon district cooling contractor who treated the 2/3 of the debt as bad debt, would it have made a difference if it was treated as a discount? How would IRB view that? Thank you.
Basically, my view is this: the IRB will look at the transaction in substance and not form. All right? It doesn't matter how the transaction was packaged, right? So it would not make the determinative difference if it's actually given as a discount, when the real reason, the true reason of that discount is given, may or may not be questionable. All right.
Thank you, Harold. James, does that answer to your question? Yeah. Any more questions from the floor? Let me check the Zoom platform as well, because yeah, we have audience from Zoom. There's no questions as of now. Yeah. Okay. If there's no more questions from the floor today, we'll just maybe end the session, end the first session. If any of you have any questions after this, do approach Desmond or Harold. Yeah, thank you so much for sharing your experience. And thank you everyone for attending and for the session.
Thank you.
Sorry.
If any one of you have any specific legal tax questions, you can certainly approach myself or Desmond. We'll be very willing to assist you on it. Thank you.
Thank you, Ms. Noelle, and our learned panelists, Mr. Harold and Mr. Desmond, for the great in-depth on tax issues in real estate and construction.
Next, the topic.
A moment, they will be making some changes on the podium.
Next, the topic for the second section is dissecting the amendments to the Employment Act. We would like to invite the moderator for section 2, Ms. Teoh Yi, and the panelists, Mr. Ankit and Mr. Rohan, to come to the stage. Welcome.
Ms. Teoh, the moderator for session 2, is the Senior Associate of HLP. Her practice areas encompasses a wide range of litigation disputes involving construction disputes, contractual disputes, execution and enforcement, injunction and probate. Without further ado, Ms. Teoh, the floor is yours.
Good afternoon, ladies and gentlemen. My name is Yi. I'm a Senior Associate in Herald & Lam Partnership. Let me first start by introducing our two speakers for this session. Next to me is Ankit, Mr. Ankit R. Sanghvi. Ankit is a partner in Hiew and Quek. Ankit completed his LLB at the University of Wales, Aberystwyth in 2010, and thereafter proceeded to complete his bar at law with the Honourable Society of Lincoln's Inn in 2011. Ankit also holds a Master of Science in Construction Law and Dispute Resolution obtained from King's College London. Ankit's focus area of practice is in construction law, and he has handled significant assignments involving energy projects, engineering projects, and infrastructure projects for both local and foreign clients. Ankit is also a certified educator with the AIAC. Ankit's experience further branches out into advising on labor issues, industrial relations, collective bargaining, industrial actions, trade disputes, contracts of service, reorganization and retrenchment, occupational health and safety, employee provident funds and social security, statutory benefits, dismissals, judicial review, administrative law, and union issues. He has also appeared extensively at all levels of the Malaysian court hierarchy for judicial review applications and appeals. Our second speaker is Mr. Rohan Arasoo. Rohan is a partner in Harold and Lam Partnership. He joined the firm in November 2015. He has more than 16 years of experience in litigation and dispute resolution. Rohan has appeared as counsel at all tiers of Malaysian courts. He also acts as counsel in arbitrations and in adjudication proceedings under SIPA 2012. He is an adjudicator and panel with the AIAC. Rohan's core areas of practice are constructions and engineering and employment and labor-related disputes. He has advised clients on various aspects on Malaysian employment law, including dismissal, retrenchment, domestic inquiry, statutory requirements, and separation schemes. He has represented clients in proceedings at the industrial and labor courts, judicial review proceedings, and other proceedings at the civil courts on employment-related issues. Rohan has participated as a speaker at conferences and webinars on issues relating to constructions and employment. He is also an advocacy trainer with the Advocacy Training Committee of the Bar Council and is a member of the Disciplinary Committee panel of the Advocates and Solicitors Disciplinary Board. Coming to our topic of the day, dissecting the amendments to the Employment Act 1955. For those of you who don't know yet, there are amendments to the Employment Act 1955 which will come into force on 1st January 2023. As a background, the Employment Amendment Bill 2021 was passed by the Dewan Rakyat on 21st March 2022 and Dewan Negara later on 30th March. Received royal assent on 26 April this year. The Amendment Employment Act 2022 was then gazetted on 10 May this year. On 15 August, the Employment Amendment of First Schedule Order 2022, setting out the changes to the scope and applicability of the Employment Act 1955 was gazetted. The amendments were initially scheduled to come into force on 1st September this month. During a press conference on 26 August 2022, the Human Resource Minister, Datuk Sri M. Saravanan, announced that the enforcement of the amendments to the Employment Act is postponed to next year, 1st January, after hearing the views of the stakeholders. Today, our two speakers will share with you their insights on the key amendments to the Employment Act in a Q&A discussion. In doing so, they will make comparison with the current provisions of the Employment Act in order to demonstrate the changes that will take place effective 1st January next year. Okay, let's start. I would like to first ask this question to Mr. Rohan. So, currently, the provision of the Employment Act 1955 apply to employees whose wages do not exceed 2,000 a month. Now, with the new amendments to the Employment Act, does the Act still apply to the same category of employees?
Thanks, Yani. Good afternoon, ladies and gentlemen. If you look at the amendments, the various amendments that are set to come into effect on 1st January 2023 in relation to our Employment Act 1955, I would say the most significant amendment relates to the applicability of the Act. As mentioned by Yani, currently the Employment Act 1955 only applies to employees whose wages are below 2,000 ringgit. So if you're an employee who earns more than 2,000 ringgit, you don't come under the purview of the Employment Act, save for provisions relating to maternity leave and sexual harassment. Other than that, you are not covered under the Employment Act, and the terms of your employment are governed by your contract of service with your employer. So even if your contract of service contains terms which are less favorable than those prescribed under the Employment Act, it doesn't matter. For example, if your annual leave entitlements or your sick leave entitlements are below what is prescribed under the Act, it doesn't matter. But moving forward, from 1st January 2023, this changes drastically simply because the Employment Act would apply across the board to all employees, irrespective of how much you earn. So whether you earn 1,500 ringgit a month or 10,000 ringgit a month or more, you are governed by the Employment Act 1955. So this would pose some challenges to business owners, to employers, because with these amendments that are set to take effect from 1st January next year, all your employees would be covered under the Employment Act 1955. So you will have to ensure that the terms and conditions of your employees' employment are in line with that of the Employment Act 1955. So if you look at the Employment Act, for example, we take annual leave entitlements. For employees who are employed for a period of less than 2 years, under the Employment Act, they are entitled to an annual leave of 8 days. Those who are in employment for more than 2 years but less than 5 years, they are entitled to an annual leave of 12 days a year. And those who are employed for more than 5 years, they are entitled to an annual leave of a minimum of 16 days a year. But this currently only applies to those earning 2,000 ringgit or below. Now moving forward, this provision and all the other provisions, all the other rights and entitlements under the Act would apply across the board to all employees. So for example, if you have an employee who earns 5,000 ringgit a month, and he or she has been working in your company for more than 5 years, and currently his or her annual leave entitlement is only 14 days a year. Moving forward, from next year onwards, that would be null and void. You have to ensure that he or she would be entitled to a minimum of 16 days annual leave. And under Section 7 of the Act, any term or condition in the in the contract of service which is less favorable than what is prescribed under the Employment Act would be deemed null and void. So we have 3 months to go before the amendments come into effect. So I would respectfully urge all business owners, HR managers to please closely review the employment contracts of all your employees, and please make sure that they are in compliance with the Employment Act 1955 come 1st January next year. Yeah.
Okay. There may be instances where a workman is not provided with a contract of service in a written form. So would such person be considered an employee under the provisions of the Employment Act?
Yes, with the new amendments to the Act, under the new Section 101C of the Act, even if an employee or if a person, a workman, does not have an employment contract in writing, the Employment Act would still apply if it can be established that the manner of work, the hours of work carried out by this person is controlled by another person. Equipment is provided by this person to carry out work for another person. Besides of which, the work is carried out for the benefit of another person. And if this person is paid for the work done, then even if this person does not have an employment contract in writing, this person would be entitled to the benefits and whatever rights that are prescribed under the Employment Act. This amendment is actually catered more for independent contractors, freelancers, your e-hailing riders, your food delivery riders, your Grab drivers, who essentially do not have an employment contract in writing. But come 1st January 2023, all of them would be protected under the Employment Act 1955. There's a presumption of an employer-employee relationship, even if there's no contract of service in writing.
Now, the most welcome and talk about amendments to the Employment Act relates to flexible working arrangement for the employees. Under Section 60P and 60Q, the employees would be entitled to apply for a flexible working arrangement from their employers. So could you, Ankit, could you please share with us your insight on the applicability of the flexible working arrangement?
Yes, thank you, Yan Yi. So the introduction of this new provision called Flexible Working Arrangements, or FWA, is a new provision in the amendment, through the Amendment Act. And essentially the provision, if you were to look at the screen, it's under section 60P. An employee may now apply to an employer for a flexible working arrangement to vary three types of things. Firstly, his hours of work, or the days of work, or thirdly, the place of work. The provision under 60Q, on the other hand, sets out the manner in which the application is to be made. Now, if we were to dissect the manner in which the application is to be made, this is the following things that we will distill from it. First and foremost, the employee's flexible working arrangement application must be in writing and in the form and manner as may be determined by the Director General. As we speak, for now, there is no such direction that has been made, so we do not know this form and manner that is being spoken about. But ultimately, the person who holds the power to set the process or the manner of application will be the Director General. The second thing, as far as application is concerned, the employer then has got 60 days to do one of two things. He can either accept the request or application for FWA, or he may reject it. If he was to reject it, then the employer must give reasons for and state the grounds of such refusal. Now, if you notice, the provision actually is, although sets out many of these things, there's still a lot of missing explanations. For example, we do not know if employers, or rather the grounds under which an employer may refuse applications. We do not know whether this is a discretion that lies purely within the employer, or does the reasoning have to be sound, justified reasoning based on certain policies. As it stands, there are no guidelines, so what I would suggest is for all employers to actually put into place certain policies, or what we call an FWA policy, which is basically to set you in motion by the time the 1st of January comes. And the reason for that is simple. It's actually a good practice to set into motion certain good policies. And I will now discuss some of the policies that you may want to consider when, as an employer, as the HR managers, you actually start drafting these particular policies. Of course, the policies can range in complexity and length, depending on the different types of industries that may be applicable. But essentially, it could be a couple of paragraphs or even as long as a couple of pages. But some very important things that I would like to share with you all is what we expect, or what I would advise to be seen in a good FWA policy. First and foremost, we should state in very clear and express terms the applicability, the scope, and the effect of the policy. For example, it should be clear from the outset who are the employers, who are the employees that the FWA provisions apply to. You may, for example, at least as of now, choose to carve out certain type of employees from applying for an FWA arrangement. For instance, interns or part-time employees, or even employees, full-time employees who are on their probationary period. You can perhaps carve them out to say that certain categories of employees will not be allowed to apply for FWA. But this is just a recommendation that I would give. Ultimately, we do not know whether there would be further guidances or notes given on this by the ministry, because if they do, then there could even be issues that, the issues that may arise could even be issues such as discrimination of employees. For example, if you choose to carve out part-time employees, would that be considered discrimination? Or if you choose to give person A an FWA policy, but person B, who's got very similar circumstances as person A, you reject him, would that be considered discrimination? So the purpose of putting into place FWA policies is essentially to set in stone with some clarity who can apply for the FWA arrangement and the manner in which the assessment will be made. Now, other than that, you would also want to state the different types of FWAs that the company or the organization recognizes. For example, the company can say that under the company's policy, FWA can only be for certain amount of days in a week, which means, say, you have to come into office 3 days a week, but Thursdays or Fridays, you have the option to choose to work from home. Or you can set certain amount of hours, for example, that you would be required to come into office every week. So those are certain, basically, limitations that you would put in place under your policy, the manner in which the FWA can be set out. Thirdly, setting predetermined conditions or limitations on the flexible working arrangements. For example, companies may allow an employee to work remotely, but subject to the limitation perhaps that the person must be within a certain location or must be within the same country even. So those are kind of limitations that you would perhaps put into place in the policy. Then you may also want to, this is quite important, set out obligations in relation to confidentiality. Employees who are going to be granted this FWA arrangement will obviously be working from a place which is not in the office. They would be in possession of a lot of confidential information. So you would want to actually put into place the type of expectations and obligations that need to be placed on employees in order for the confidentiality aspect of an employer-employee relationship to be still maintained. Next, this is again something that we do not know yet, but the question that begs to be answered is, can you, for example, set a policy to perhaps change someone's salary in light of an FWA that has been granted? So depending on the type of the FWA that has been granted, you perhaps may want to consider setting out specific type of policies. For example, a permanent reduction in working hours will mean that an employee's existing salary will be accordingly reduced. You may set a particular formula that is put in place. For other type of employees, you may also want to include details of any new allowances as a result of the FWA. For certain people, for example, who work from home, remote office equipment would be required and a setup allowance would be required. So things like this can be provided for in your FWA policy. And likewise, certain allowances may no longer be perhaps applicable. For example, traveling or parking allowances. Because you're no longer coming into the office, then such allowances would no longer need to be extended to you. So that is also something that you may want to consider putting into place in the FWA policy. Finally, the last couple of things, you would of course want to set out the company's expectations of the employees under the FWA arrangement. For example, you would want to state that even though you are working for reduced hours, you would still be required to complete the key deliverables, attend all scheduled meetings, and you would continue to abide by the company's policies and procedures. And finally, where relevant, of course, the policy should also explain that any approval is conditional upon the employee signing an FWA, or rather, I will have to term this, sorry, it's a flexible working agreement. So basically entering into a supplemental agreement somewhat to perhaps amend the relevant terms and conditions of their existing employment contracts. This is something that you would want to state in your policy so that if and when a particular employee applies for it and you decide to grant that employee with the right for FWA, then he also is aware that there perhaps may be amendments made to, by way of a supplemental contract. So to sum up the entire FWA provision, I would say it is indeed a welcomed provision, but we are yet to see what is going to be the market reaction to it, how employers are going to be dealing with it, especially considering that we have a very wide range of different industries which would have different types of nuances that would be required. Thank you.
I guess employees like me would be happy to welcome this provision, flexible working arrangement, but it seems like the employers are going to set some limitation to this. Okay. Apart from employees having the flexibility to work from home when the amendments to the Employment Act it takes effect from 1st January 2023, are there any changes to the working hours for the employees?
Yes.
Mr. Rohan, yeah.
Under the current Employment Act, an employee shall not be required to work more than 48 hours a week. But this only applies to employees who earn less than 2,000 ringgit. And the thinking behind this is simply this, because an employee is not earning very much, he or she is earning less than 2,000 ringgit. So the employer should not expect him or her to work unduly long hours, not expect the employee to clock in 10 hours, 12-hour shifts daily when he or she is only earning less than 2,000 ringgit. Now, moving forward, from next year onwards, from 1st January onwards, the statutory working hours per week has been reduced to 45 hours, from 48 to 45. And the problem, the potential problem for business owners, for employers is this. The Act will apply across the board, irrespective of how much the employee earns. So even if the employee earns 10,000 ringgit or 20,000 ringgit or more a month, based on the amendments, this mandatory provision would apply, where an employee cannot be required to work more than 45 hours per week. And currently, if we look at the amendments, there are no exceptions. There is no proviso to say whether there are any exceptional circumstances in which an employee can be required to work more than 45 hours per week. The only exception is this. For example, if you're an employee earning less than 4,000 ringgit, he or she would be entitled to overtime claims. But if you earn more than 4,000 ringgit, you will not be entitled to any overtime claims. So to me, this potentially poses a big problem to employers. And let's face reality. All of you here who are in the real estate and construction industry, or even lawyers, we all know it is not feasible for us to just limit our working hours to 7 hours a day or 8 hours a day. There would be a need for us to work beyond our prescribed working hours, simply because of the demands of our jobs. We have projects to take care of. For lawyers, we have cases to attend to, trials to prepare for, hearings to prepare for, so it's not feasible. So moving forward, looking at the amendments, basically, if you take a 5-day working week on average, which is the current norm, an employee is expected not to work beyond 9 hours a day. So let me pose you this question. What happens, say for example, you have an employee who has worked from Monday to Thursday, and he has clocked in 40 hours of work from Monday to Thursday. Can he then come and tell you, boss, sorry, on Friday I'm only going to work for 5 hours because I've already worked 40 hours from Monday to Thursday. And the Act says I only need to work 45 hours per week. So Friday I'm coming in at 9 o'clock, by 1 or 2 o'clock I'm off. You cannot ask me to work beyond that. That's the law, and I'm also not entitled to overtime claims. So the answer to this remains unclear, and we really need some guidance from either the Human Resource Minister or the Director General of the Industrial Relations Department, or perhaps even the courts. Yeah, so this is where we are. But having said that, I must say that this prescribed working hours per week is actually in line with the working hours in many other countries around the world. For example, in the European Union, countries falling within the EU, their prescribed working hours is 48 hours a week. In the US, it's 40 hours per week. Closer to us in Singapore, the prescribed or the statutory working hours per week is 44 hours per week. In China, it's 40 hours per week. In Japan, it's also 40 hours per week. Thailand, 48 hours a week. India, 48 hours a week. And of course, Scandinavian countries, we know how flexible their working arrangements are there. So they are required to work less than 40 hours a week. Yeah, so this is where we are. It's a potential problem, but let's see how things go. And I would think perhaps the enforcement of this provision may not be so strict. So there should be some leeway given to employers.
What about sick leave entitlement for employees? Would there be any changes pursuant to the amendments?
Yes, there is a minor change. Currently, employees are entitled to a maximum of 60 days sick leave per year, and this includes hospitalization leave. So, for example, if you're an employee who has, say, utilized 10 days of non-hospitalization sick leave, and then suddenly, for some unfortunate circumstances, you fall sick and you have to be admitted in hospital, you would be then entitled to paid hospitalization leave for maximum of 50 days because you have already utilized 10 days non-hospitalization sick leave. Moving forward, employees would be entitled to 60 days hospitalization leave apart from your non-hospitalization sick leave. So your sick leave, non-hospitalization sick leave can range anything from 14 days to 22 days or beyond. And then separate from that, you would be entitled to 60 days hospitalization leave.
Thank you. Another notable amendment to the Employment Act relates to the maternity leave and paternity leave. Many female employees have been pushing for longer maternity leave entitlement as they feel that the current entitlement of 60 days is insufficient and is not in line with the entitlement provided in many other countries. So, Ankit, could you share with us the changes to maternity leave entitlement which will come into force next year and also the paternity leave entitlement?
Yes. Yes, thanks, Yanyi. So essentially, through section 37(1) subsection D, subsection 2, the word, or rather the number 60 is to be substituted with the number 98. So essentially, this means that female employees would now be entitled to 98 consecutive days of leave as maternity leave. I'm not sure how everybody in here feels about that. Obviously, we have some who would be very happy with it. But from an employer's perspective, this could be, again, painful to the wallet, simply put in very harsh words. But the amendment, or rather the extension of the maternity leave provision from 60 to 98 is actually in line with recommendations by the International Labour Organization, which basically states that governments should guarantee 98 days of maternity leave. So essentially, we have met the bare minimum requirement that has been set by the International Labour Organization. Now, there are two ways of looking at this. One is by way of actually contrasting our position with other countries. And I will leave that to your individual selves to evaluate whether we are in a better position or in a worse position. But simply put, there are many other jurisdictions who actually provide female employees with much longer maternity leave. As Rohan has pointed out earlier, the Scandinavian countries in particular, Croatia, Denmark, Norway, Bulgaria, Czech Republic, and so on, have got very pro-female maternity policies, meaning to say that the period for which leave can be taken is a lot longer than 98 days. Take Finland, for example. This is just in the news a couple of days ago. They have recently, both parents are actually entitled to parental leave of 164 days each. Parents are further, in addition to this, just to make things even more interesting, parents are able to transfer about 69 days of their own leave to the other parent. So for example, a father who does not want to utilize his full 164 days allocation, he's allowed to actually give out 69 days to his wife. But to make things very interesting is this. Out of this period, 26 weeks are paid out of 70% of the employer's salary. For the remaining weeks, employees are given a flat rate. So simply put, you may be given longer leave, but you're not actually being given full salary. And this applies in many other countries as well. Slovenia, for example, gives 34 weeks of maternity leave, but they will only pay you up to 75% of your salary. In Croatia, interestingly, they give you 30 weeks, but they will pay you the full 100% salary. So it varies from country to country. And when we talk about paternity leave, Yanyi, if you could please change the slide, this is also very interesting because this is a whole new provision. It's not an extension from 60 to 98, but this is a whole new provision coming into existence for the very first time to be in line with other jurisdictions. But what does subsection 60FA state, which is essentially the statement dealing, or rather the provision dealing with paternity leave? First and foremost, there are several conditions. The male employee must be married to the mother in question to be entitled to the maternity leave. This may seem very obvious, but it's not, because people do have kids out of wedlock. So you will not be entitled to paternity leave, assuming you're not married to the lady in question. Secondly, he must have been employed by the same employer for a period of at least 12 months. So if you're a new employer, or rather you're a new employee of just 6 to 8 months or so, you will not be entitled to paternity leave. Finally, you must notify your employer at least 30 days from the expected confinement, or even earlier than that if possible, of your notice to utilize this paternity leave. So essentially the number of days is 7 consecutive days. That is the law in Malaysia. This is actually in trend or in line with many other jurisdictions. But for example, just to draw comparisons again, we have other jurisdictions which actually offer much higher paternity leave. Japan, for example, actually gives you 1 full year of paid paternity leave. But here's the catch. Pay for the first 6 months is at 67% of your salary. And for the balance 6 months, it is at 50% of your salary. So you're getting a much longer leave period, similar to maternity leave, but the salary that you would be taking home is not full. In Norway, you would take 15 weeks at 100% pay, or 19 weeks at 80% pay. So again, this is an option given to you. You can either choose to take 15 weeks and get paid your full salary, or take 19 weeks and get paid a reduced salary. The option is yours. In France, 4 weeks is the paternity leave provision, and employers are responsible only to pay the employee for the first 3 days of the 4-week period. The rest of it is actually paid by the government. So again, this is very interesting because the Malaysian government hasn't made any or hasn't given any support in terms of financial backing for maternity or paternity leave. Even in Japan, for example, the entire pay, when I meant pay for 6 months at 67% and pay for the balance 6 months at 50%, the entire pay, would you believe it or not, is actually paid by the government of Japan. So employers do not lose out. So this is something interesting because we have comparables in other countries, and we also have the existence of government supporting particular employee relationships in this manner. But in Malaysia, we don't see this yet. So whether or not this is going to be a pinch on employers is something that we will have to see. But there is a cap or limitation as far as male employees are concerned. They may only apply for this paternity leave up to a total of 5 confinements, regardless of the number of spouses that they may have. So 5 confinements means that if you have triplets, it doesn't count as 3, it will still be 1 confinement. Thank you.
Thank you, Ankit. Mr. Rohan, like what Ankit has just said, there seems to be more protection for pregnant employees under the new amendments. So I understand that there will be an offense for the employers to terminate pregnant employees except in certain circumstances. Can you tell us more about this?
Yes. So as Ankit alluded to earlier, for female employees, there's not only an increase in terms of your maternity leave entitlement from 60 days to 90 days, but under the new amendments, you would also be given protection against termination. So if you're a pregnant employee, and if you unfortunately suffer any post-pregnancy illness, which requires you to be hospitalized or to take bed rest at home and you're unable to work, an employer cannot terminate you from employment irrespective of how long you are away from work, how long you're hospitalized or how long you have to be at home to take rest. An employer would only be entitled to terminate a pregnant employee if that employee commits a willful breach of the employment contract. If there is misconduct on the part of the employee. Or, for example, the employer has gone into financial difficulties and has decided to close its business. Only under these exceptional circumstances would a pregnant employee, can a pregnant employee be terminated. Currently, if you look at the Act under Section 42, if a pregnant employee suffers post-pregnancy illness and is unable to come to work for a period in excess of 90 days, the employer actually has the right to terminate her employment. So moving forward, this cannot be done unless there's a willful breach of a contract of employment or if the employer decides to close its business. So this is the additional protection provided to female employees.
Thank you. Let's move to another area, sexual harassment. Okay, sexual harassment is an issue that is frequently talked about these days. There have been widespread calls for sterner laws to be implemented to tackle sexual harassment, especially at the workplace. Does the current employment law provide adequate protection to employees who are subjected to sexual harassment? Ankit, and could you share with us your views on how the amendments to the Employment Act deal with this issue? What must be done by the employers to create awareness on this issue of sexual harassment at the workplace?
Okay, sexual harassment laws have been in existence in the Employment Act even before these amendments. It has already, it's been defined as any unwanted conduct of a sexual nature, whether verbal, non-verbal, visual, gestural, physical, or directed at a person which is offensive or humiliating or is a threat to his well-being, arising out of and in the course of his employment. So it has already been defined under the Act. The Amendment Act actually does not make any of the laws any sterner, but rather it imposes a new obligation for employers to put into place or place the exact words, to exhibit at all times conspicuously at the place of employment a notice to raise awareness on sexual harassment. So essentially this is really just to raise awareness. The laws do not change, but now there is an added obligation on employers to actually put a sort of a signboard in a conspicuously located position. Conspicuous, by the way, simply means in a clear and visible location. So you may put it on a notice board, you may put it on your pantry, or wherever that is deemed to be conspicuous in your subjective assessment. But essentially this is really to raise awareness because a lot of employers, a lot of employees may not know what is the extent of sexual harassment laws under the Employment Act. I'm just going to cite two cases here. One is Morgan Maniam against Saim Dabi. In this case, the claimant touched the complainant's back and caressed the complainant's hip multiple times. The claimant invaded the complainant's personal space, almost hugging her in order to retrieve his water bottle. This was actually deemed as sexual harassment under the Act. Another case, Loganathan Maniam against Murphy Sarawak. This, by the way, the earlier case was in 2021. This case of Loganathan Maniam and Murphy Sarawak Oil is actually 2020. The claimant called the complainant Sayang publicly, gave her unsolicited presents such as perfume, hand cream, floral phone cover, and chocolates on Valentine's Day, touched her cheeks and sent her suggestive messages via WhatsApp, and instructed her to carry out outside her job scope duties, such as picking him up from the airport, following him to buy his attire for a team building dinner, and expecting her to show him to his hotel room during the team building event. So these are all examples of sexual harassment which have been, people have been found liable under the Employment Act provision. So this is perhaps the reason why they want to raise awareness by having to place this particular signboard or a notice at your premises. Thank you.
Okay. What about discrimination happen at the workplace? Mr. Rohan, perhaps you could take this. This is a fairly common occurrence where employees complain that they are being discriminated by their employers. May I know what sort of protection are afforded to the employees who face discrimination at the workplace by the new amendments?
Yes, by virtue of the new section 69F of the Employment Act, in the event an employee is discriminated at the workplace, he or she may now, or rather from 2023 onwards, lodge a complaint to the Director General of the Industrial Relations Department, who may then investigate the complaint. And the DG is entitled to issue an appropriate order to the employer. And if we look at the amendments to section 69F, it has been cast rather wide. It does not identify what sort of discrimination. So I would think discrimination is just not limited to gender discrimination or racial discrimination. So if an employee, for example, feels that he or she has been discriminated in terms of increment or other employment-related benefits, he or she potentially can lodge a complaint to the DG on the grounds of discrimination. And in the event a complaint is lodged, the DG investigates and the DG finds that yes, the employer is guilty of discrimination, the employer would be deemed to have committed an offense, and upon conviction, the employer can be fined not exceeding 5,000 ringgit. And if the employer continues to discriminate the employee, then the employer is liable to a fine of not exceeding 1,000 ringgit for each day of non-compliance. So one thing, this amendment shows that discrimination is now being viewed more seriously, as discrimination appears to be a common occurrence at the workplace. In fact, if you look at our industrial law reports, the past cases, a lot of cases where employees have resigned and pursued a claim for constructive dismissal, it has been on the grounds of discrimination. So this is being viewed more seriously now. So under the new amendments to the Act, added protection now is being provided to employees to ensure that they are not discriminated. If you look at the current Act under Section 60L, discrimination is only limited to foreign employees. So employers who hire foreign employees must ensure that the foreign employees are not discriminated as opposed to local employees. But moving forward, discrimination applies across the board. So if any employee feels he or she is discriminated, then he or she is actually entitled to lodge a complaint against the employer.
I see. Okay, now many of our participants today, they are from the real estate or construction industry. It goes without saying that it is a common practice for developers and or construction companies to hire foreign employees or foreign workers to undertake development and or building works. In this regard, could you please share with us the provisions relating to the hiring of foreign employees under the new Amendment Act? Ankit?
Yeah. Okay, so we have Section 60K, which has been amended. And under Section 60K, the previous provision, which is 60L.
Yeah,
sorry.
Can I get the next slide, please?
Yeah, I apologize, but I'll just carry on anyway in the interest of time. So the previous section basically said that employers who hire foreign employees were merely required to inform the Director General of new foreign employees, along with details within 14 days of employment. With the new amendment under 60K, the duty has become a lot more onerous for employers. Now you would require the prior approval from the Director General of Labour before employing foreign employees. An application for the approval shall be made in the form and manner as may be determined by the Director General of Labour. For now, we do not have the form and manner yet. But ultimately, upon approval of the Director General of Labour, an employer again is required to, within 14 days from the date of the employment of that particular employee, furnish the Director General with the particulars relating to the foreign employee in such manner as the Director General of Labour may direct. The Director General of Labour may, subject to any written law, approve an application if the employer complies with the following conditions. Yeah, I'll just read them out. The employer satisfies the Director General of Labour that on the date on which he makes the application, he has no outstanding matters relating to any decision, order, or directive issued under the Employment Act, or he has no outstanding matter or case relating to any conviction for any offence under the Employment Act and various other acts such as the Employees Social Security Act and so on. Further, that the employer has not been convicted of any offence under any written law in relation to anti-trafficking of persons and forced labour. So basically, they are holding you by a leash. You must comply with whatever directions that have been given, decisions, orders, or directives that have been given which affect your organization or company. If you fail to perhaps adhere to the orders or directives, you will not have your approvals granted for future foreign employees. Furthermore, there is again a requirement that if the service of a foreign employee is terminated by his employer or by reason of the expiry of the employment pass issued by the Immigration Department, or by reason of the repatriation or deportation of the foreign employee, again, there is now an added duty on the employer to inform the Director General of Labour within 30 days of the termination of service in the manner as may be determined by the Director General of Labour. As I mentioned, the manner and the form has not been prescribed yet. We will have to wait to see what they actually say in regards to this. And finally, if a foreign employee terminates his service or absconds from his place of employment, again, there is a requirement for the employer to, within 14 days of the termination or after the foreign employee absconds, to inform the Director General in the manner as may be so prescribed. Thanks.
Thanks. Okay, coming to our last question, Mr. Rohan, what about the provision relating to general penalty? So currently, any person who commits any offence under the Employment Act or contravenes any provision would be liable to a fine of 10,000 on conviction or less than 10,000. So may I know, is there any changes to this penalty?
Yes, there is a change. There is a significant increase in the penalty from next year onwards. So from 10,000 ringgit, it will be increased to 50,000 ringgit. So if any employer is found to have not complied or who has contravened the provisions of the Employment Act 1955, the employer can be fined up to 50,000 ringgit. So once again, I would humbly urge business owners, employers, to please take note of the amendments to the Employment Act. HR managers, please study through the Employment Act in detail, because any non-compliance by the employer could result in a fine of up to 50,000 ringgit. So please take these amendments very seriously, and as I said, you have about 3 months before the amendments come into force. So please review your employment contracts, your employee handbooks, your employment policies, and make sure that they are in compliance with the Employment Act from next year onwards. Yeah, thank you.
Okay, thank you for the informative and interesting talk, Mr. Ankit and Mr. Rohan. I think we are running short of time. If there are any questions from the floor, can you please approach our speakers later at the coffee break? Yeah, thank you so much, everyone.
Thank you, everyone. So sorry we are not able to take any questions because of time constraints, but if any of you have any queries, please feel free to approach Ankit or myself. Thank you.
Thank you, Ms. Teoh, and our learned panelists, Mr. Ankit and Mr. Rohan, for providing great insight on the recent amendments of the Employment Act.
Ladies and gentlemen, we will now have our short coffee break before we continue to the last panel discussion. Please join us at the dining room at the lower ground floor. Our next section will be 4:20 p.m. See you later. Ladies and gentlemen, welcome back. We have now come to section 3, where the panelists will be discussing the challenges faced by the developer and contractors at the stage where the project is ready for delivery. This section will be moderated by Ms. Amy Hiew Kar-E, and the panelists for this section are Ms. Lynn Fu, Mr. Thoo Huan, Mr. James Tan Kok Kiat, and Ms. Lim Justin. We are pleased to welcome the moderator and the panelists to come to the stage.
Ms. Amy Hiew, the moderator for Session 3, is the partner of HLP. Her main practice areas are corporate and commercial dispute resolution. Besides dispute resolution, Amy is also involved in corporate drafting and project advisory. Before I pass the floor to our Session 3 moderator and panelists, once again, I would like to give a gentle reminder that we have 70 minutes allocated for this panel discussion. When the session has another 5 minutes left, our production team will give you a friendly reminder or notification. If you hear the second friendly reminder or notification like this, we would be grateful if you could kindly wrap up the session. And now, Ms. Amy Hiew, the floor is all yours.
Thank you, MCs. I'm Amy, as introduced. I hope you all had a good coffee break earlier. I will just now introduce the panelists. First panelist, Mr. James Tan, gentleman in the middle. James is the CEO of Suntrack Developments in Sdn Bhd, a multi-award winning developer with over 20 years of track record in property development. The awards include the Star Property Award for Best Semi-Retirement Residential and the prestigious FIA-BCI Award 2019 for Best High-Rise Residential Development. James is currently the National Council member for REDA Malaysia and Chairman for Planning Policies and Standard Committee. Our second panelist, Mr. Thoo Huan, Mr. Thoo, on my right, is a senior partner in Halim Hong and Kwek Dispute Resolution Department. He is also in the HHQ Risk Management Committee. Mr. Thoo is one of the panel solicitors of the Advocates and Solicitors Disciplinary Board and a member of the Inter-Pacific Bar Association. He also once served in the Malaysia-China Commercial Law Corporation Committee under the Malaysia-China Business Council. Mr. Thoo has been in practice for 25 years in the area of dispute resolution. He's actively engaged in trial and appellate advocacy at all levels of the Malaysian courts and regularly appears as counsel. He also regularly provides foreign expert opinions on Malaysian law to Foreign Competent Court of Jurisdiction and Arbitration Forum. Mr. Thoo is one of the panel lawyers advising REDA and assisting REDA in holding watching brief for court matters where REDA is an interested party. Our third panelist, Ms. Lynn Fu, is a partner with Hera & Lam Partnership and focuses primarily in infrastructure, construction, and engineering law. She is one of the main liaison partners for HLP's China desk. Lynn regularly advises and represents developers, contractors, and professional consultants on projects across a variety of industries, including retail, residential, power plant, MRT, healthcare, tourism, and highways. Lynn also assists her clients on various non-contentious issues, such as drafting and vetting consultancy, building, and other construction-related contracts. Our fourth and final panelist, Ms. Justin Lim. Justin is one of the partners in HHQ from the Real Estate and Banking Department at their Kuala Lumpur branch. She advises and represents a variety of property developers and individuals in a full range of conveyancing matters. From the very initial stage of project development, she advises developers on matters relating to the development of master plans, submission and amendments of parcel or building plans, as well as perusing architects' drawings and specifications. Prior to the sale of parcels, Justine also advises on the best strata strategy to the developers. Being well-versed in strata laws, Justine is regularly sought by property developers and management bodies on matters relating to strata management. Apart from that, Justine is also frequently sought by REDA for her professional opinion on issues in relation to property development and strata management. She has been involved in discussions with the Special Task Force Committee, along with other stakeholders on the proposed amendments to our current laws on property development. I understand that our title today is on project delivery and the challenges that developers and contractors may face, but you will soon realize that in our discussion, we may touch on on issues outside project delivery as well, and we thought that those issues may be useful for our audience today. So perhaps to kickstart our first issue or topic for discussion among our panelists is the issue of imposition of Bumiputra quota, like minimum sale of units and the discounts. Perhaps I can pass the floor to James and Justin on this.
Hi. I must start by qualifying that the government has good intention to maintain harmony in the distribution of wealth and property ownership. Good intentions. I must start by saying that. Now, however, legally and structurally, and whether the government can do so or not is a separate matter. Because the National Land Code or the Town and Country Planning Act does not allow for such provision. And you will notice in your alienation approvals or subdivision approvals under Section 204A, 204B, which governs land use, premium and rates and other matters, they have used the Part D other matters to include a Bumi quota. Now, in the 1979, there was a famous Sri Lanka versus the PDG KL case, and the chief judge, I think it was Sufyan, said something about how the government does not have an unfettered discretion. All must be act within reasonableness, the Wednesbury test apparently. Sorry, I'm not legally trained, so I'm quite proud when I can speak like that. So therefore the 204A and 204B under other matters does not reasonably allow a government to impose Bumi quota, Bumi discount, and furthermore does not allow certain states to collect penalty in release of the Bumi quota, because collection of any form of funds is deemed a form of tax, and under the federal constitution, the law must allow specifically for it. It does not. You will not find it in the National Land Code or the Town and Country Planning Act. So therefore, the position that REDA got as a legal opinion is that Bumi quota, discount, imposition of penalty is unlawful, despite the best intentions. Thank you.
Justin, would you like to add?
Yep, but developers still paying the penalties for the Bumi quota release. And also, just to brief everyone that the Bumi quota regulations normally is applied to the Bumi units, and also through a 30% of minimum mandatory quota on the developers, and a minimum of 7% discount on the properties. Okay, so the state government has the jurisdictions of over the land matters, which is including to impose the Bumi quota together with the penalties on the Bumi quota release. Okay, when the developers is unable to meet the Bumi quota for the projects, then they need to apply to the state for the Bumi release to sell the units to the non-Bumi purchasers. So, for example, in Leng, it's very clear that there is a perkeliling, which is penetapan kuota Bumi Putra dalam pelaksanaan pembangunan tanah, which is under the perkeliling under PDG Selangor. So, of course, the developers have a very clear instructions and also guidelines that they have to meet some requirements, and also they have to do the 3 months advertisements to get the Bumi quota release. So, the penalty also stated very clearly to be imposed on the developers if, let's say, they get the approval, okay? So for residential property, 12% of the selling price will be the penalty. For commercial property, 50% of the selling price. And for industrial properties, 15% of the selling price will be imposed upon the approval of the Bumi quota release. But in KL, there's no guideline, no written notice from the state. Okay, from the authorities. The condition that we know is the developer can only apply the Bumi quota release upon the completion of minimum 50% of the projects. Okay, and they also have to prove that the non-Bumi lots has already sold out. And the payments of the penalty is 5% of each and every property selling price. Okay. However, in Negeri Sembilan, the Bumi quota release can only be applied 1 year after the CCC obtained. Okay, and also it will take, based on the feedback from developers, sometimes for some projects, they even take more than 1 year, 2 to 3 years, then only they can get the approval. So of course, upon the applications, the developers have to provide the evidence that they already advertised in the local newspaper, but there's no response from the Bumiputra communities. And upon the approval from the Bumi release from the government, then only the Majlis Mesyuarat Kerajaan will inform the developers how much they need to pay. And also the amount to be paid is really based on case-to-case basis on the projects. So, and there's one thing that I need to highlight is, upon the Bumi release in Negeri Sembilan is obtained by the developers, if the property is under freehold titles, there will be a restrictions to be stated expressly in the titles. So consent need to be granted upon for any transfer and also charge.
Yeah.
Can I add the practice of stating Bumi Putra title or Malay use title as practiced in Malacca and Johor, I recall, it's not provided for in the National Land Code again. I just want to make one closing remark on this topic,
Sure.
is that while the audience, the developers make the commercial decision, it is important that you know your legal position of where this thing stands. At one point, Negeri Sembilan was going to control all properties, social housing and free price properties where price were to be determined. And I was getting a bit excited because thinking that, you know, now the government has finally pushed too far, and our members in Malacca may finally have to take this to court and use this, what I've just shared with you. So it's a matter of how far you make your commercial decision. Thank you.
And then still on the issue of conditions, and this is one of conditions, another condition that may be imposed would be the collection of contribution fund, as I understand, usually for the upgrade of public street and all that. Maybe again, James, you can share, and also Justin, based on your experience, do you encounter issues with that? And you know, what are the practical ways that you have, you know, used to address those challenges and issues?
It's very easy to hold a developer at ransom at the application stage for planning approvals, building and infra approvals. And again, developers often make commercial decisions, time versus trying to find out who's right or who's wrong. And you know, and the city council, state governments will often push the boundary. First now hang on a second. Improvement Service Fund is provided for under the Street and Drainage Act. No one's arguing, disputing that. That's Act provided, okay? But the situation comes like, can you upgrade the traffic light down the road? Oh, down the road, okay, it's related to my project. Can you upgrade the bridge 2 kilometers down the road? And where do you start pushing the boundary on and on and on? And it's a common practice now in a lot of city councils where they collect contribution per acre of your development, and that interchange can be far, far away, or recently they'll ask you to upgrade some public amenities here and there. Radar is very privileged to work with Justin, HHQ, to come up with a legal opinion and advises very clearly that the Street and Drainage Act has made provisions very clearly on what can or cannot be done. I'll leave that to Justin.
Yes, under the Street Drainage and Buildings Act, public street is under the maintenance of the local authorities, the state authorities. And also under Section 8 of the Act, it's mentioned very clearly that the local authorities can only recover the cost from the frontages or the developers' concerns, okay? However, I think the local authority did collect contributions.
In advance,
yeah, in
rather
advance,
than recover.
Before the completion of the work. So actually under the Act, the local authority cannot do so. There's no express provisions for them to collect any money from the developers. Only there's one section on the drainage work.
That one's in the form of a deposit. Yes.
Yeah, deposit basis. Okay, and also there's one section 132 under the Act only provide the establishments of the improvement service fund by the local authorities, which is also there's it's not the statute and giving the legal powers to the local authority to collect any monies.
Beyond that.
Yeah,
yes.
correct. So I would like to share one case, Retina in Penang. Retina Developments, Sendirian Berhad versus Majlis Perpandaran Seberang Pride. In this case, the Majlis Perpandaran has demanded the developers to pay monetary contribution for landscaping, tree planting in lieu of the applicants, who is the developers, having not physically carried out the work. The High Court held that the local authority has no power under the legislation to impose any conditions on the approved layout plan, that the applicant must make a monetary contribution in lieu in fulfillment of the specific conditions imposed. So the court also held that such action is illegal and unlawful. Okay, so the court has ordered the local authorities to refund the amount to the developers, and the developers have to comply with the condition for the landscaping and tree plantings imposed by the local authorities.
I just want to make a point. The city councils can recover the cost from the frontages and the developers concerned. Frontages and developers concerned, I have 3 pages from Justin already. And frontages are defined as people who stand to benefit from it. And why would the city council define that to only include developers? How about the factory down the road who benefit from the improvement in the road and traffic, or the neighborhood down the road? It's a much wider net. So that's also one issue. Second one is developers concerned. If the bridge is 2 kilometers away, where's the reasonable test? So such are the questions.
And also the bridge definition is not under the public street, it's under the definition of building.
Yeah, anyone make contribution for bridge yet? Oh, no one? Oh, okay. Yeah, bridge is not a street under the Street and Drainage Act. Okay, thanks.
Thank you. We on to the next topic, or rather a topic of conversation among developers. I think most of you here would have heard of cases like Ang Ming Lee, Alvin Leong, the PJD Regency case. So much has been talked about it, and perhaps we have Mr. Thoo here who can share with us briefly what is the current position, legal position, and the current developments, and what we can expect to come.
Yeah, thanks, Amy. Welcome, everyone. I think by now, all developers would have known this Ang Ming Lee case. So I would not spend time in explaining what's the case about. But safe except I will briefly tell you some recent development that involve arising from this case. As all of us know, the Ang Ming Lee case has been decided in such a way to say that the EOT, the extension of time granted by the housing controller, is rendered invalid. And therefore, all the cases arising thereafter, okay, has been so-called being attacked by the purchasers to claim the LAD, even though they have earlier signed the SPA for 48 months. But now they are reverting back to 36 months by relying on the Ang Ming Lee case. So now there's a dilemma to be faced by the developer whether they need to build the project development as per the 3 years period for the Schedule H, or they can still rely on the EOT granted by the housing controller. If based on the Ang Ming Lee case, definitely the court has been, so many cases has decided that you cannot. They are entitled to claim the LAD claim based on the 36 months. However, there are uncertainties recently, or for the past 1 year. I think the cases has been keep on flipping here and there. At one stage, the lower court may have decided in favor of the purchaser, but in other cases, it's the other way around. They decided in favor of the developer. Then, in most of the cases, when it go up to the higher court, let's say high court, the high court judge will overturn the decision in the lower court. So it keep on going, then keep on appealing until the last hurdle they can face, which is in court appeal, whereby as at today, there are still more cases in favor of the purchaser rather than the developer. Let me also explain one reason the development on this procedurally the law in allowing the summary judgment. Previously, the purchaser, once they file the suit, they will file a summary judgment application. If the summary judgment application in lower court, let's say, assuming it's filed in lower court, the session court judge allow the summary judgment, then the developer still have a chance to appeal further. This is as at now. If the summary judgment application has been dismissed, the purchaser is also entitled to appeal to the High Court. But starting from 1st October this year, there's been amendment to the Court of Judication Act, whereby, let's say, if a summary judgment was being dismissed, the purchaser is not entitled to file an appeal to a higher court. It means that whatever decision, it means that if the summary judgment is not being allowed at the lower court, then the subject matter will proceed for trial. That means that you still have at least 6 months to 9 months before heading to the trial. Okay, let's come with the most recent development, which I think most of the developer is very anticipated of this outcome, whereby this Ang Ming Lee case has one opportunity again to be revisited in federal court. This is the first ever case that reached federal court. So far, all the cases, they are unable to get past the Court of Appeal hurdle, whereby they need to get a leave before they can appeal to federal court. But this case, there are 2 cases mainly. It's from the Prema Bonanza, whereby 4 cases arising from 4 different applications went all up to the Court of Appeal, whereby the leave finally has been granted by the Court of Appeal for them to appeal further to federal court. And there are 7 questions being posed eventually will be heard at the federal court. Okay, let us go through the 7 questions of laws that I think most of the developers are really concerned of, because all these issues will affect the so-called the decision later on. As you can see, question 1 is being posed in the Court of Appeal, whereby the federal court will have to hear it because leave has been granted. It stated it's as whether a sale and purchase agreement for housing accommodation of a high-rise building between a purchaser and a developer, which provides for a period for completion of the housing accommodation extended illegally under the ultra-virus regulation 11.3 of the Housing Development Control and Licensing Regulation 1989, should revert to the 3 years period as provided in the Standard Schedule H agreement. And if this being answered in affirmative, then the federal court will then look into the question 2. The question 2 says whether the cost of action for the late delivery liquidated damages shall accrue to the purchaser only upon the expiry of the said 3 years period. And following that, the question 3, which is also related to question 2, whether the limitation period of a claim for the late delivery liquidated damages shall commence only upon the expiry of the 3 years period. These 3 questions actually being posed arising from the Obata case decision, whereby the Court of Appeal have decided that the limitation period will start calculated from 6 years from the SPA date. 6 years from the SPA date. That means that it's not from the late delivery expected date. i.e. there is a shortened period whereby the purchaser are being stopped from filing the suit after the 6 years of the SPA date, and not from the expected delivery date of the vacant possession date. Then we have question 4 to 7, whereby is more related to the developer as a whole. As you can see, question 4 stated that as this: does the doctrine of prospective overruling and the exception set out in the Re-Spectrum Plus case apply to Malaysian cases where a court decision and or a judicial pronouncement would bring disruptive consequence to an industry as a whole? This is the first time the federal court will actually look into this, whereby the impact to the whole developer industry created by this prospective overruling. As you all know, the Ang Ming Lee case has been decided such a way that the court nowadays applies the retrospective overruling rather than the prospective one. So that's why a lot of the cases, even though happen after the Ang Ming Lee case, they still revert back to the Ang Ming Lee decision. So this question 4 will again invite the federal court to make a landmark decision of whether this Ang Ming Lee decision will apply retrospectively or prospectively. Question 5 is also related to this prospective overruling pronouncement. It states that does the reliance test, i.e. the greater the reliance on the law or legal principle being overruled, the greater the need for prospective overruling, apply to Malaysian cases whereby reliance was placed on a statutory regime. Questions 6 and 7, I think basically is based on the limitation period again, whereby it reads, when does time for a purchaser's claim for liquidated ascertained damages start to run under the Section 6 of the Limitation Act 1953, whereby a purchaser and a developer enter into a sale and purchase agreement prescribed by the Schedule H of HDR. B, the SPA expressly states a time frame of more than 36 months for delivery of vacant possession under Clause 25 and completion of common facilities under Clause 27, the extended period. C, the purchaser claims that the extended period deviates from the 36 months prescribed by the Schedule H of the HDR. And D, the purchaser consequently claims that the LAD from the developer for that part of extended period which exceeded the 36 months. The last question to be answered by the federal court eventually will be whether a purchaser is to be taken to have enjoyed benefit at the expense of a developer when the developer is required to pay the additional LAD claim to the purchaser pursuant to the statutory agreement prescribed under the Schedule H of the HDR, having duly adhered to the extended time period for delivery of vacant possession and completion of the common facilities as agreed by the purchaser and the developer. In another way, the court is actually to determine whether the purchaser are being stopped from claiming a different situation whereby the earlier they have agreed to the extended period of more than 36 months. So with these 7 questions, I think once and for all, or at least this at that stage, the federal court will again revisit the Ang Ming Lee decision, whereby there are certain lacuna being left behind that has not been resolved by Ang Ming Lee case. So these 7 questions, I believe, is much benefit the industry as a whole, because eventually whatever decision or principle being made by the federal court will have a certain impact or even change the landscape of the whole LAD claim. And there's another new development, actually, whereby recently there at least 3 cases being filed by the developers directly against the housing minister and also the housing controller. In these 3 cases, now, they straight away bring the 2 parties, i.e. the government, in the short term, will bring along, the government into the suit, whereby they are being named as a defendant. And what are they claimed? Have been claimed in this suit. Basically, these at least 3 cases, all the relief being claimed there are quite identical. Okay? In short, they're actually asking a declaration from the court to announce or declare that the extension of time given by the housing controller is valid. And the EOT by the controller under the ministry letterhead considered a valid delegation of power, or alternatively, they are being made under the hand of the minister pursuant to his administrative power. In all the 3 suits, they are also seeking that the minister have to make necessary steps to ratify the decision granted earlier via the EOT being given by the housing controller. And again, another relief that they are seeking in the suit is also asking that the Ang Mili case to be applied prospectively and with no retrospective effect. And lastly, also in the relief, they are also seeking indemnity from the government as an alternative prayer. These 3 cases is still quite fresh, whereby the first case will be heard is on the 7th October, okay, whereby the decision may be given or will be deferred another date. But as far as we know, it will be heard on the 7th October. The first case out of these few cases filed against the government directly. I think Amy just now also touched on this PJD case. I think the PJD case, all of us know that is regarding the booking fee issue, whereby the purchaser not only claiming the LAD based on the extension period, but also the pre-signing SPA period, whereby they want to calculate from the booking fee they paid. I think currently, the latest development will be there are at least 5 cases pending at the federal court to hear the motion whether leave should be appealed, leave to be granted for the appeal on this booking fee issue. So this is still pending. It's supposed to be heard, I think, few rounds ago, but it was been adjourned few times also. Until now, there's no hearing date being fixed yet by the panel. So as of now, the stage is still, these cases pending appeal to the federal court if the leave is granted. Then I think some of the clients did ask me, so can any way that we can distinguish PJD case? Since the PJD case is the federal court decision. Well, I think there is a quite an interesting development whereby in 2021, there's one court of appeal case they have decided to distinguish PJD case. And in that case, the court has held that the purchaser themselves have contributed to the delay in the signing of the SPA, as they only secured a loan from the financier about quite a unduly delay after the booking fee being paid. So as such, the Court of Appeal have decided to depart from the PJD case, since what they say is the developer should not be penalized for the purchaser's own conduct. And to the so-called, as at now, this Court of Appeal case is still the highest authority, because we have been told also the purchaser have attempted to appeal to the federal court. But however, the motion has been dismissed. So that means that they cannot appeal to the federal court on this decision, whereby the decision is the only authority so far that has distinguished PJD Regency. whereby if the booking fee issue arise, I think the developer have to look into the situation, why the SPA was not being signed within a reasonable period of time. If that being contributed by the delay from the purchaser themselves, then based on this court appeal case, it can be distinguished from the PJD Regency case. I think for these two cases involving Ang Ming Lee and the PJD Regency, these are the few developments that have been so-called still ongoing. I think what we really need to wait is for the federal court to actually hear the 4 appeals arising from the Prima Bonanza case. So as at now, they are still at the stage of the case management. So hopefully I will assume by next year, the hearing date will have been fixed. I think that's for the sharing of the development on this EOT issue, whereby the LID is one of the crucial impact that have been hit against all the developers nowadays.
Thank you, Mr. Thoo. Sorry, I just want to ask, like James, from developers' perspective, have you encountered this issue, and what other issues arising from this? Perhaps you can share your experience.
Yeah, I have a personal experience on this. We got 42 months for a project. It's supposed to end in July 2020. And December 2019 was when the Ang Ming Lee case was decided. And then we had to make an executive decision and go like, no more 42 months, it's 36 months. It's now January 2020. So we had to rush and hand over a project, even though the housekeeping was not completed, within 2 months, because we just couldn't risk it. So that was my personal experience. I just want to make a distinction about Ang Ming Lee case. Ang Ming Lee case was where the extension was granted during construction. And the industry view, my personal view, is that's not fair to the purchaser. But the distinction must be made, and to the public, they must know, the distinction must be made to cases where purchasers knowingly entered in an SPA that the period has been varied and extended to 48 months or whatever period that is. It's very clearly different where, purchasers enter with their eyes wide open. And there are projects now where the purchasers and some, if I may, not so professional legal professions going around, the word's touting, right? Going around collecting people to come, let's sue the developer, and do things like that. And I find that, and to the members here, if that happens to you, apparently you can get a order against touting. I don't know what you call that order, that document against touting. You can legally stop that person from touting. Yeah. So that's that. The damages to our industry is in the billions. And I'm glad you raised the case on the three cases where they named the minister as one of the respondents. And I think they've been very polite to only ask for an alternative prayer for the indemnity. Basically, you're trying to say that all of us have extended our delivery period based on the permission given by the Ministry of Housing. We can't be suffering the entire damages on our own. Eventually, we'll bring the responsible party into the picture and say, you gave us an extension, now we're in trouble, we're going to get you in. Thanks.
I think maybe add on a bit. I think I do agree that I think the trend now is the class action suits have been filed against the developer, as opposed to suits filed by individual purchaser. As you can see, I think most of the cases nowadays, I think in court, it involves class actions. It means more than 90 purchasers or even more than that. The suits, no longer like the olden time whereby the individual filed their respective suits. Then the other thing I want to add on is, having said so, what we have discussed just now, that doesn't mean that the minister cannot issue the EOT. I think based on the Alvin Leong case, the court had decided that the minister himself has the power to give the EOT.
Under a different section, right? It's not 11.3.
Yeah, under a different section.
Justin, you want to add on?
Yeah, I just want to add on something and highlight that now the approval of the extension of the completion period is still signed by the controller, Datuk Jaya. So, but in that approval letter itself, it's stated in the first paragraph that the minister has already considered under Section 22 of Act 118. The wording is, Menteri telah bersetuju memberi pengecualian bagi pemajuan berdasarkan Section 2 Akta 118. So this is the wording that added in the approval letters. However, the extensions of the completion period is not the only issue. We have another issue is on the extension on the issuance of strata titles, actually. The certificate that issued by KPKTs. Because under the Schedule H, the strata title have to be issued upon delivery of vacant possessions. But this one is better than the EOT matters because this, the developers is allowed to get the certificates from the KPKT on the extension. However, is what the developer have is just approval letters. It's not a certificates.
The wording of an approval letter versus a certificate, but it's clearly stated in the sales and purchase agreement that the developer can get an exemption from the controller in the event the strata title is not issued in time. But there's a catch to it. You need to get your CCC first, and that exemption to hand over without strata title takes about a month. So you just lost 1 month to your delivery period, and now you have 35 months to complete your house. That's one thing to look at. And my personal advice to the developers here, despite the recent letters signed under Section 22, I won't bet on it. Please fall back to your 36 months if you can. Thank you.
And Datuk Jaya also it's like we have been informed by KPKT that the approval letters will be gazetted in bulk together. Yeah.
Okay. I guess.
As we speak, Halim Hong and Quek is working with RADAR in reviewing the Act 118. I saw the document. I couldn't finish reading it. There's a lot of proposals and comments. It's a long and painful process to amend the act, and even at RADAR, we are managing our expectations of how many of the proposals and suggestions that we made will be received.
Thank you, Mr. Thoo, Justin, and James. Moving on to another area on issue faced by developers when delivering a project would be defects, right? So before we get to defects, let's talk about the quality issue. I understand there are some confusion in quality assessment as well as the quality standard that is applicable in Malaysia. Would you like to share more on this?
So there's a new profession called home inspectors who will charge you 500 ringgit to give you a very thick report of your house. And I suspect a lot of the stickers were added by the owners themselves, not just the inspectors. That's just a personal speculation. And in their report, they refer to CIS 7. CIS stands for Construction Industry 7, published by the Construction Industry Development Board, CIDB, under CIDB Act. But a lot of people fail to understand CIS 7, if you read the subheading, it is a quality assessment tool. It is not the standard itself. The standard, you got to refer to Jabatan Standards Malaysia for your MS 2616, MS 1910 for firefighting. They have MS for ceramic tiles, they have MS for everything. So the CIS 7 is a tool. And some of the clauses, some of the checklists under the CIS 7, for example, is if your tile has a leakage of more than 1 mm, it's 0 point. Note, it's 0 point. It is not defective or substandard because it's a tool. And the tool requires, and you read the tool in totality, it is a sampling tool. You're not meant to check every single piece of the tile for defects and leakage. So these are the kind of confusion and expectation from our purchasers who will come up, and these are the kind of issues that developers face. And notably, it's been brought to a tribunal. So I'll let Justin cover that.
Okay, just to brief everyone that under Schedule H, and also Schedule G, there is a defect liability period for 2 years for the purchasers to claim the defects from the developers. So now the trend is that 500 is too expensive already. Now it's 200 to 300. Okay, per a report with 50 pages. Yep. So now the trend is the purchaser will engage it's called home defect inspection reports, which prepared by home inspectors under Home Inspection Malaysia and approved by a senior home inspectors who is the member of the CIDB and certified home inspectors.
No. They could be an accredited assessors, but there's no such profession as a home inspector yet.
Oh, okay.
They created that name for themselves.
Yeah, this is stated in the report.
Please don't mind my emotion about this. Yes.
Yeah, so the developers, defect teams have to check one by one. 50 over pages. They will and have the report is very detailed with the analysis and also the summaries of the defects. So and also in tribunal, it's adopt the inspection report also. Okay. Actually, we have called out KPKT, the Bahagian Tribunal. There is no standard forms or defects form that when come to defect issues to be claims in tribunals. So the purchaser actually can also submit these defects inspection forms to the tribunals when come to the defects claims. So we come across there's one case that we found out that in tribunal Johor Bahru, the technical teams, okay, it's like that. Tribunal will, when come to defects claims in tribunal, the tribunal normally they will appoint one technical committee, which is a technical team to inspect physically to the house and do the assessment of the alleged defects. So a defects report, technical inspection report will be produced by the team. But in the Johor Bahru Tribunal case, the technical teams actually has submitted their report by applying QLASIC. QLASIC is what James mentioned, CIS 72021, also known as QLASIC or classic report. There actually is a standard assessment system for scoring, is for rating and scoring purposes. So the technical teams actually has submitted the report based on the QLASIC assessment system, and actually the tribunal has awarded the purchaser on their claims against the developers. So now I think we have no further, the updates on this case. I don't know whether developers will go for judicial review or not.
I think they should, but I also suspect, I'm not sure how well they defended themselves, whether they understand the limitations of a CIS 7 versus Malaysian standards. So, yeah.
Actually, there's a question posed online. Maybe I can just read it. Relating to defects, but may not be exactly what you have shared. The person asks, what's the right of purchaser if the defects occur beyond the LP period, the defects liability period? Maybe Justin.
The rights of the purchasers. Yeah. So then the limitation amendment, latent defect comes to mind.
They still can claim if, let's say, they can prove to the court that it's latent defects, which is really from the workmanship by the developers.
You have to prove that it's a latent defect, and it's quite tall order. From what I recall, Radar and HHQ had that webinar where we
together with Lynn,
where we brief our members.
Do you want to?
On the latent defects part, I think the developers should be mindful that the Limitation Act has been amended. So it's no longer 6 years, it's actually 15 years. And how it's calculated, it's basically in accordance to the Amendment Act. Yeah, basically there's some way of calculating, basically it's now 15 years. So that's one thing that the developers need to be mindful of, yeah.
In that webinar, we had a claim consultant who draw examples from Singapore.
Yeah.
And in Singapore, they treat the Limitation Act as an act of tort. So one has to prove the damages, and one claims directly from the person who caused the damage. So there was an opinion that in Singapore, you don't come after the developer, you go after the you go after the plumber who installed a defective pipe.
Basically, if I'm not mistaken, Singapore's position quoted by, I think it was Mr. Saw. It was basically they say that they can actually claim against the builders and also the consultants as well. Yeah.
Instead of the developer.
I mean, that would be the developers to actually pursue against.
So the developer has a role to play. We have to prove that we have acted reasonably and carried out our duty in inspection and ensuring that the building was built accordingly. Then, so it's quite a tall order, even with that 15 years for the purchaser to prove latent defect.
Yes.
And if certain things, the latent defect is usually, it implies hidden, yeah? Implies
basically hidden defects. Basically defects that's not able to be discovered during your, based on your naked eyes. Right. Yeah, so it actually occurs like maybe a few years down the road. And how this defects is defined is basically it's based on how an expert, perhaps a building checker, based
architect
on the report,
or building
or
inspector,
architect. Yeah, that's right.
And distinction must be made very clearly from wear and tear. So certain things like the toilet gadgets and mechanisms, there's a wear and tear element to it, and also subject to declaration of warranty made by the manufacturers. They have designed it to last 10 years. This exposed tank is designed to last 10 years. Done. So it is not a defect. It's not a latent defect per se.
Yeah.
Okay. Yeah. Thank you. Still on defects, so we have looked at from developers, and I understand this defect issue. Contractors they too, face a lot of issues with defects. Even after handing over of the project, their works to developers, to the employers. Maybe Lynn, since you deal with contractors more, would you like to share what are the common challenges or issues that contractors face in this respect?
I think two recent issues that was faced by my client is that one of it being them, despite handing over the works and CPC not being issued. Reason being because they didn't actually comply with the conditions stated in the contracts. Basically, there are certain requirements that perhaps the contractors overlook, like firstly is the notification part. Secondly is the requirement to actually submit the O&M manuals, drawings, and perhaps the guarantees and warranties, and also certain approvers as well. They actually failed to provide all these necessary documents, which actually resulted in CPC not being issued and LAD being imposed. And one difficulties in that is that because of the cubic electronic case, right? And right now, LAD, actual loss no longer be required to be proven. Yeah, so something that the contractor face is that right now they are the one that is required to prove what is reasonable. Whether the LAD amount imposed is reasonable or not. Yeah. And another issue that my client faced is they mentioned that towards the tail end of the project, there's actually a lot of variation works that come in without any written instructions. And towards the end, when they tried to claim and whatnot, then of course, without all this documentation, then they are unable to claim. So that's also one issue as well. That's why I think, just to echo what Desmond mentioned earlier, even during his tax issue, I think proper record keeping is very important. So I think it's not really related towards the end, but I think one thing that parties, either contractors or developers, they need to be mindful of proper record keeping, and also to basically get all the documents in order as well. The communications, whether it's a legal notice or instructions, all this has to be properly kept as well. Most of the time when our client come to us, it's often too late. When we requested for this and that, and nothing is in order. That's what. This is the two recent, major issues that my client has. But of course, there are some other issues like the site issues or cash flow problem, all these things. Cash flow problem, I suppose a lot of contractors would be aware of SIPA, but another thing that the contractors or perhaps consultants need to be mindful of is what are the appropriate forum, because with the development of law and the interpretations of courts, whether SIPA is as effective as before, it's very hard to say, because we have a client actually wanted to claim for loss and expense. After filing SIPA, came to us and realized that actually SIPA is not that efficient, and perhaps going to court might be a more appropriate forum instead. Because of the complexity of the claim as well. That's from contractors' perspective. Maybe James can share from.
Can I add on and I speak fairly?
Sure.
I mean, CPC is Certificate of Practical Completion, and there's a definition in the PAM contract on CPC. The word practically completed. So if it's practically completed, and the important documents like your as-built plan that's required for your CCC are all in order, and if, for example, a warranty for a water heater is missing, you shouldn't use that against the contractor and not grant CPC. So I think contractors must know their rights and seek what is fair. So, I seek what is fair, right? So that would be my view on CPC. And secondly, the no instruction part. Don't ever do anything without an instruction. That's a given, man. Sorry, I sound so layman now. But yeah, that's a given. So you must always wrap up your documents and if instructions were given late, those are all grounds for extension of time. You prepare accordingly. And let's be fair as well, right? Even though I speak for a developer, if you give a last-minute instruction and then you want to penalize the contractor for not delivering on time, that's not fair. So again, it's back to documentation. Thanks.
You are a very good developer.
We seek to be fair.
Yeah.
Thank you.
Right. Thanks both. Since we have a bit of time, let's move on to one last issue. I think a lot of contractors or developers now face issues relating to shortage of raw material and labor. Maybe Lynn, you can share your thoughts on this issue, or have you encountered this in your practice recently?
On this issue, I guess this is something that a lot of contractors actually, it's a major problem because of these issues, also because of competition. Then they actually have to keep their bid price suppressed throughout 2020, even up till now, just to, secure a project. What I've heard from some of my clients is that they actually work with the developers to basically come into an agreement or consensus on how to resolve this together. Besides raw materials, shortage of workers is also an issue as well. So I guess maybe we meet someone like James, then perhaps, I don't know, there wouldn't be such issue. But we also have some clients which are sort of like in a dilemma, whereby the employer didn't want to compromise. Despite the spike in the raw materials and whatnot. I guess on this, from a contract drafting perspective, I think what the parties can do in future is basically to consider to have some sort of clauses, basically to rebase or to be able to just have some revision so that this wouldn't be an issue in the future. Basically, in light of these issues, this sort of clause, I would suggest that basically to put it with conditions, such as in order to allow for such a revision or rebasing, to impose conditions such as if, let's say, there's an increase in cost that has adverse impact on the contractor's businesses, or circumstances arise which cannot be reasonably foreseen, and this is beyond the contractor's control, like let's say a sudden global shortage in raw materials. The next question the developer might ask is that then the contractor will come now and then to say that I want to revise the price. It's unfair to me, right? So to actually counter that, it's basically to actually have some sort of clauses to tighten it up. Basically, to have clause to state that the contractor would be required to actually provide all the necessary information to show that such rebasing or revision is reasonable. So it'll be subject to ultimately the project owner, the developer's discretion. Some sort of clauses like that, yeah.
I seek to be fair, but I may not seek to be, is it magnanimous or charitable? I seek to be fair. We can't vary our costs. Yep. Our house price are fixed. And we're all in the business of managing risk and cost. Yep. So if we accommodate the request to vary the cost, we're being kind. But if we don't, we're not being unkind. We're just merely following what's been set for and handshaken. In many countries, like in Australia, it never come across their mind to renegotiate the rates. You lose money on this project, I hope you make money in the next project. That will be the stance with the contractor. Yeah. I mean, look, as a contractor, you always have options. And if the material rise way beyond and you stand to lose way too much, you could always walk away from the project, risk your performance bond and your reputation being burned. But there are always options. So, I mean, we, the developer, we can't hold you there forever too. So, yeah.
Yeah, I guess it's like what James mentioned, it's business risk that the contractors need to take as well. Yeah. Yep.
I mean, when you come in for a tender, you price accordingly to what your projection of the cost is. You do your own research. We do our own research. When we bought our land, by the time we launch, it's 3 years down the road, or maybe faster for some of the developers here, but still, right? We're all in the business of managing our risk and cost.
Thank you. Since we have just a bit of time left, I'll go with our last question for all our panelists here. What do you think is the next phase of challenge you foresee developers and contractors facing in the coming year or coming 2 years? Maybe whoever.
That's really wide. The Strata Title, under the Strata Titles Act, purchasers are required to transfer, register their title within a month. But only one sentence. Doesn't say if you don't, what happens. Maybe there are some clauses at the end that says if you breach, then what are the penalty, 50 years or whatever is deleted, I don't know. So that's an operational issue. A lot of our developers are holding on to titles forever. The owners refuse to transfer it because they don't want to pay the MOT. So but we want the government to step in because this can't be going on forever. And in some cases, the VP is handed over, and within 12 months, the strata title is issued, so we can't form JMB, and then we need to wait for 25% to form MC, and yet a lot of the owners don't transfer. Then it will become developers management period for a prolonged period, which is unfair too for both parties. So such one of the issue. Okay, I've done one turn.
Just add on the strata titles matters. Okay, now another challenge that an issue faced by developers is whether to collect the custody fees to maintain the titles in the custody of developers or all sent to the lawyers as stakeholders. So this is the matters that always the developers will come to us and ask us. So
SMP doesn't provide for that though. Can you actually collect a fee?
There is a minimum of 500 admin charges. There is a court case, yeah.
Oh, is it? So we'll just pass on to the lawyer and let the lawyer charge? You can do it, we can't.
Under the SRO, actually, we can charge.
Yeah, because you represent the purchaser, you're protecting their interests, you hold their title.
But some of the developers, they don't trust the lawyers.
Oh, no.
Yeah, because we have to prove that
we'll
we
let
have
you
a proper...
acknowledge, receive your IC that you took the title. Finish.
Okay, pass your all to us.
Shouldn't talk so much.
Okay, besides that, we also, I think the developer will be facing also the different rates of the maintenance charges under the stratified building in the mixed developments. So because of the Rajawali case, the court decided that the MC and the JMB is not allowed to fix the different rate of maintenance charges.
I thought JMB cannot, MC can.
Both cannot.
Thank you for your advice.
For different types of components in mixed developments. So unless or until there is a new amendments of the Strata Management Act, this issue definitely will haunt all the developers.
Or you form sub-MC, but requires 75% transferred.
No, this is a different rate issue.
But if you form sub-MC, then you can charge different rate for each sub-MC.
You still need to have a uniform rate, but with another rate on the exclusive use of the common property.
Yeah, correct.
Mr. Thoo or Lynn?
I think I've actually shared the challenges for contractors already. I mean cash flow issues and all this procurement of raw materials and shortage of workers. It will continue. I mean, it's inevitable. Yeah.
Mr. Thoo?
Maybe I can add on the uncertainties that the developers facing now due to the court cases. So beside the LAD claims, they also will be burdened by the legal fees that they need to fork out to appeal from one stage to another stage. This will be quite a great challenge for all developers. Then beside this, what I can think of is the challenges in rectification to rectify the strata titles later on. There are cases whereby the developer have requested us to apply to the court to rectify the strata title based on the omission or even accidentally attach wrong parcels. Oh, yeah, yeah. So if that situation happen, it will affect the share unit as well. So the recalculation of all the units there need to be done by the surveyor. So this has been some so-called difficulties in getting the surveyor to pay again the surveyor in a sense, whereby you need to pay again for them to prepare another report to submit to JUPEM, whereby the court order will reflect that order to actually order the JUPEM to do the rectification and to register the strata plan. So, and there are cases whereby there are different practice by the KL Land Office and the Shah Alam Land Office, whereby we have faced some difficulties in getting a court order from a Shah Alam court. But on the other way around, in KL court, I think it's easier. So there are different practices, so-called being used by different land officer. So I think this will be some challenges that may be faced or be even to be dealt with by the developer if, let's say, there are some mistakes being made to the strata titles.
Can I add on that? I speak in defense of the civil servants in the land office and survey department. It is true that a lot of delay in strata titles are actually due to the errors in the building plan approval and the strata title, the ciphers, the strata plan. So not all delays are due to the land office and JUPEM. And to that question of the rectification of the error requiring court order, the professional architects and the professional licensed surveyors should bear the responsibility over such errors. And that's something that we developers accommodate at times. Yeah, thanks.
We have 5 more minutes. We'll take questions from the floor first before I read out some of our questions from our Zoom participants.
No one wants to ask question about EOT. Free advice, you know.
Well, maybe I'll just read out one of the questions on the EOT letter that I think Justin mentioned just now. The participant asked, under Housing Control Act, Minister is allowed to grant EOT. However, if the EOT letter has been signed by the representative from the controller or KPKT, but not the controller chairman, what is your opinion?
Unless it is gazetted under 2.2, section 2.2, if not, it's still open for the purchaser to challenge. Yes.
Okay. Thank you. And sorry.
Maybe I add on a bit on the so-called letters issued by the controller. So far, what we can see, there are differences in the letters issued by the controller. Some letters, they sign on their own behalf. Some, they say on behalf of the ministry. Some even say it on behalf of the housing controller. So there are some so-called confusion or being created by the letters themselves. So if let's say I think there's a more proper guideline in future after the amendment or whatever, or even arising from the Alvin Leong case, the minister himself should sign the EOT. That will clear all the doubts, because that is the actually being provided by the statute and also by way of the court case, Alvin Leong. So to avoid any confusion or misunderstanding or even some ambiguity later on to be challenged in court, I think it should be a good practice for the minister himself sign the EOT, rather than letting his subordinate or whoever being so-called assigned to sign the EOT. That will solve the problem actually.
Okay. I think another participant would like to ask about the calculation of the 15 years that you mentioned just now on the defects and latent defects. Exactly how that works. Maybe Lynn can explain.
I'm trying to actually open my notes. Can move on to another question first, sorry.
I can't recall whether it's 15
because I
from
can't,
VP or SNP. Yeah, I can't recall that. But you can read the Limitation Bracket Amendment Act. There's an example there.
Yeah, under Section 6, there's illustrations of how this 15 years is being calculated. So basically, there's some sort of illustration mentioned in Section 6A of the Limitation Act. Yeah.
Okay, thank you. So sorry to the participant.
I just want to note that the Limitation Act does not apply only to property, despite the
Yeah,
illustration
despite
being
the
used as property.
illustrations, yeah,
It could
yeah.
well apply to your cars as well.
It can be cars as well, yeah.
And this is just for everyone here and also those online for your information. We will collate the cases that we have referred to by the panelists today, and then with the organizers' help, perhaps when we send out, we can try to send out the list, because I think some participants are asking for the full name of the cases that you all referred to earlier, so I'll collate that and send that across so that everyone has that. If there are no further questions from the floor, thank you everyone, and thank you to the panelists, and I hand back over to the MCs.
Thank you, Ms. Hiew, and our thank you, Ms. Hiew, and our learned panelists, Ms. Lynn, Mr. Thoo, Mr. James Tan, and Ms. Justine, for bringing us a very, very productive section today.
Mr. James Tan, please step down to the front of the stage. Thank you. And we would like to invite Dato' Quek, Managing Partner of HHQ, Mr. Lam Wai Loon, Co-founder and Partner of HLP, accompanied by Mr. Leon Gan, Partner of HHQ, and Felicia Lai, Associate of HLP, to deliver the token of appreciation to Mr. James Tan. Thank you very much, Dato' Quek, Mr. Harold, Mr. James Tan, Mr. Leon, and Ms. Felicia.
As we come to a close for today's conference, we would like to invite Ms. Serene Hugh Man Yi, the partner of HLP, to deliver the closing remarks. Welcome.
Hi, good evening. I'm fully aware and I'm the last one standing between you and your cars and your journey home. So just give me a bit of patience as I close. I just have a few people that I need to thank for today's seminar. I think first and foremost, I would like to express my appreciation to the speakers and the moderators for their contribution to our very first seminar. I mean, special thanks to Dato' Ho, who had to leave early, and also Mr. James Tan, who have agreed to take some time off their busy schedules to speak today. My deepest gratitude, of course, goes to all of you here who made it in person to our seminar, and of course to those online. I've been told quite a number of our clients actually joined on Zoom, so which is great. And the committee will help to make this seminar such a successful event. But the joint committee led by Mr. Leon Gan was asked to organize this seminar in a very short period. So I'm very glad that they did it, and I'm sure with loads of help from L2 and Cindy. Most of you here this afternoon are invited because you are our valuable clients whom we call friends of HLP and HHQ, and we hope that this seminar will be a catalyst of something greater in the future. What we hope to do is that we want to have better opportunities for the exchange of ideas and for ways for us to also add value to you and your organization. So we have heard a little bit about, I think, the first session on tax. And there was a few takeaways that I came. Number one, importance of record keeping. Number two, there's this term called badges of trade that we learned. I learned something new today. And number three is whether with the extensive of liability of a director, whether there's a need for you to now relook at your shareholding and directorship. In the employment talk, this one sparked quite a lot of discussion over tea just now. I can hear some of you start to think my flexible working arrangement, my 45 working hours a week, you may not see me on Friday anymore. So this kind of things, and I think it's great that it's sparking conversations. So I don't intend to speak very long today because I know it's traffic jam, but we do have a networking session. So since traffic has started, so stay back. Let's just have a good discussion over tea and drinks. I'd like to convey special thanks to each organizing committee. I'm not naming all of them here today, both from HLP and HHQ, and of course the AIAC for accommodating us at such a short notice. Both the MCs for officiating today's event, which is great. So thank you again, everyone. Have a good evening.
Thank you, Ms. Siri Q.
With that, our HHQ and HLP inaugural joint conference has officially come to an end. Ladies and gentlemen, on behalf of HHQ and HLP, we would like to say thank you for your active participation today.
We sincerely hope that today's conference has been fruitful for every one of you who have taken your precious time to join us today. And for those of you who are So for those of you who are here with us at the AISC, please do not leave just yet, as we would like to invite all of you to stay here and stay back and join us at the pavilion foyer for our post-event cocktail networking section.
Okay, just to guide you guys on how to get to the pavilion foyer. So the way will be by taking the lift to the LG floor, and then the lift to go to the pavilion foyer will be at the car park. So at there, the ushers will guide you guys to the pavilion foyer. And not forgetting our virtual participants, thank you for the questions and thank you for being with us here today. And I hope we can see you guys all in the next event. Thank you.